Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends, and thank you so much for coming to hang out with me today. It's Tuesday, March 17th of 2025, and Karen Reed was still framed. The only person who's happy about the Karen Reed trial barreling down the track right now is Dr. Harry Turk. If you know, you know. I was going to cover the Turk hearing today live at 2 o'clock, except apparently they're so busy at the Norfolk Superior Courthouse today that they can't even turn on the Zoom feed for Dr. Harry Turk. So we pivoted, and it's a good thing too, because I can't even download these motions fast enough right now. I can't even download the motions fast enough. So for those of you who feel compelled to email them to me, please, you can stop. Thank you so much. I appreciate you as always so very much. Except when my inbox is getting so clogged up that I can't find what I need, it gives me anxiety. So thank you so much. But it is the 11th. Did I say it was the 11th or the 10th? It's the 11th. If I said the 10th, I'm sorry. It is the 11th. It is the 11th. You know what happened? My cursor, I have to look to the corner of my screen to see what day it is. And I had the cursor over the 1. So it's 11. It's 3/11. 3/11/25, and Harry Turk is happy today because nobody's paying attention to his case. All right, for the many people who sent me the email, the YouTube video of the gentleman who purchased the Lexus taillight and smashed it with a hammer, and it's really super thick. Amazing, I did see it. Thank you so much for all of you who sent it to me. I've seen it. Boozy Beauty also did a great video on it. We're not talking about that today because today I have about 700 motions to go through with you, as well as I am not going to talk about the Better letter today. Many of you have already seen it. Did I say the 17th? You know it's my favorite holiday. St. Patrick's Day is my favorite holiday because you don't have to buy gifts for anyone. And it's just like a big party. And, it's crazy. So, yeah, good for that creator whose video went viral. But today we are focusing on the motions in Lemonade, which are the discovery motions, actually the evidentiary motions to decide what will and will not be allowed in at the Karen Reed trial. And there are a lot of them. The deadline was yesterday, and so they are just hitting the docket today. And as they keep coming and coming, we will cover them maybe in chronological order because, why not, right? So let's see, a lot of things that I see in here in the docket that I had expected, some other things that are a little bit unexpected. So it's going to be a long one today. It's going to be a marathon, you guys. So grab yourselves a drink, grab yourself some snacks. You want to stay hydrated. And we're going to be here, I guess, for as long as it takes. Because you know what? We ain't got no quit. We ain't got no quit. That's right. All right, let's see. So it looks like the first thing that came out today was 557. So I can only pull up a couple at a time because, you know me, I have too many tabs open often and it's not good. So there's 557, 558. And let's do 559. We might as well be chronological today. Merge. All right, you guys ready? First, let's start off and thank you. Thanks to Cosmic Blue became a member. Welcome. Sandy Thomas became a member. Welcome to you. Tracy Walker, always gifting. Gifted 5 memberships to those of you who were gifted by Tracy. Welcome and give thanks to Tracy. On top, thank you for being here with the super sticker. And Veloma Unstuck here to ride the retrial wave with you, Melanie. Quite ridiculous to have gotten to this point. Yeah, I know. Prayers daily for Karen and her team. Thanking me for the consistent coverage and the best chat. We do have the best chat. Thank the moderators because really I could not do it without the moderators. They're amazing. And they work double, triple overtime. And we know it's going to be a marathon today. So we're here for it. Settle in, my friends. Settle in and buckle up. And to those of you who were waiting on Turk, I apologize, but they're not. Nobody's going to be streaming it live, so there's nothing for us to talk about today. If the video does come out, like last time, the video came out maybe like a week later. Like Court TV was there, they just didn't broadcast it. So I do not want you to think that I have forgotten about justice for Katie McLean because I have not forgotten about justice for Katie McLean. And who's the judge for Dr. Turk? It is. I believe it's Judge, unless I'm conflating my judges, it's Judge Halal. No, wait, or is it Judge Frenier? Judge Frenier is on Brian Walsh and is Judge Halal, who is on Harry Turk. And we do have a viewer who is in the courtroom today for Harry Turk, so hopefully she can give me some more information later, and we can talk about that. All right, so let's see. Where did I say we were starting? At 557. So that's not the right screen. So hang on one second. I started redlining some of them, and then it just got overwhelming because there are so many. There are so many. But we're here for it. And here we go. The first one is docket number 557. Docket number 557. What I'm going to do later when I have time is I'm going to go in the show notes and I'm going to timestamp everything for you. So if you just want to go back and you just want to review one of the motions, you can know exactly where to find it. I like to do it by docket number rather than name of motion because that's easier, but I will give you both. I will give you both. Yes, Bettero sent a letter to Rafferty. I did see it. I don't have time to go over that today, but I will at some point. And yeah, we'll see if Rafferty does anything about it. I doubt it. I don't think she will. Don't go outside to D&E Pizza because if you do, they will record you audio and video. And apparently that's against the wiretapping laws. So Bettero, here's the long and short of it. Bettero sent a letter to Helena Rafferty. I'm not sure how she pronounces it, and I don't really care. The chief of police of Canton to advise the chief of police that Chris Albert, who happens to also be a town selectman in the town of Canton, who's actually her boss, has been illegally wiretapping everybody who's outside on the sidewalk of D&E Pizza because apparently in Massachusetts it's illegal to record audio. You can record the video, but you can't record the audio, even if it's in a public place. And so he has asked, our friend Mark Bettero has asked the chief of police to bring charges against her boss, Chris Albert, the town selectman, who's out there recording people all the time. And so we'll see if anything comes of that. It'll be interesting because Here's the thing. If she doesn't bring charges against Chris Albert, it's as if you didn't already know that there was absolute proof that Canton PD and MSP selectively prosecute certain people that they just don't like. It will then be solidified if she does nothing about Chris Albert. And, the thing is that he can't really say that he doesn't know anything about the law, because ignorance is not an excuse. It's not a defense. Ignorance of the law is no defense. And so there's that. For those of you who are wondering, like, why the hell does your thumbnail say motions in lemonade? It is because one day the closed captions, which we love, called motions in lemonade. We've adopted it. It's part of my opening song, my theme song, and we're going with it. All right. First on the docket today, docket number 557. This is the Commonwealth's motion for a protective order. And what the Commonwealth is asking here is for the court to establish a protective order restricting the public dissemination of all communications to be provided to the defendant on March 10th, on the 10th, which was yesterday. No, I just explained it. So did you get it? Did you get it? Did you get the pun there? The motions in lemonade. I'm not on mute. If you think that I'm on mute, then you need to refresh your browser. Refresh your browser. It's motions in lemonade. Closed captions called motions in lemonade. How long to bring charges, Beth? I don't know. When, if ever, will Canton PD bring charges against Town Selectman Christopher Albert, brother of Brian Albert and brother of Canton Police Officer Kevin Albert? And you just can't make it up. You just can't make it up. All righty. Okay, so the Commonwealth is asking for a protective order restricting public dissemination of all communications that were supposed to be provided yesterday, according to this motion, as detailed in their notice of discovery number 61, which I don't know could be in my inbox right now, but we'll have to take a look at that to see whose communications those are. They say this order is necessary to effectuate the well-established privacy and safety interests of witnesses and the victim's family. Okay, so it'd be interesting to see whose communications those are. Furthermore, certain materials being provided as discovery in this case may be evidence in an unrelated pending criminal case. Well, if the unrelated pending criminal case is Aidan Carney, then that's a very interesting argument that you're making there, Ms. Brennan, because your argument, not even your argument, because you didn't put it in your papers, it was in your thoughts, the thoughts that you decided you had to share with the court when Mark Betterow wanted to be admitted pro hoc vice and Karen Reed wanted Mark Betterow to be admitted pro hoc vice as part of her defense team. It was your position that those cases actually are related and that the defense team for both Aidan Carney and Karen Reed have been sharing some sort of state secrets and therefore, don't let Betterow on. And she believed it. So if that is now what he's saying is an unrelated pending criminal case, yes, they keep moving the goalpost, right? Right. You are absolutely right. Minion Haas. That's right. Brennan the sly. He's not so sly. He thinks he's sly. So yeah, it'll be interesting to see when I see the notice of discovery 61. I think it's probably Aidan Carney's text messages. And so now they're unrelated, but apparently they were so related that both defense teams were sharing secrets, and therefore now Mark Betterow has been denied pro hoc vice admission because of the judge's determination that there's a conflict. Without ever talking to Mark Betterow, without ever talking to either Aidan Carney or Karen Reed, they both signed off on it. They both had attorneys. The whole thing is ridiculous. We're in the Twilight Zone, upside down, Narnia of hell. That's where we are. The issuance of a protective order is the inherent authority of the issuing court, of course. She's the gatekeeper to hell. And protective orders serve to shield litigants and third parties from unwarranted disclosure, and as a practical matter, to facilitate the discovery necessary for a trial. The Commonwealth agrees that this protective order be set without prejudice. Meaning what? That you can unseal the stuff later? XOXO. Oh, this is actually consented to by the defense. So you see that's a stipulation. Why did he say motion for protective order? Why didn't he just say stipulation for a protective order? somebody's trying to sandbag him, and it may be his paralegal. She may hate him, and then the judge so ordered it. So it's already been granted, although we haven't seen yet today the notice of discovery number 61. So we will, when it comes time to look at that, if we see it, we will know what these communications are. Moving on to docket number 558. Docket number 5. I've got Harry Turk on the brain. Docket number 558 is defendant's motion in limine to present demonstrative exhibit based on Christina Hanley's testimony. This is, I mean, you know that Massachusetts is a weird jurisdiction, but apparently you need like permission from the court to show exhibits, or what they call chalks, which I guess is because they used to be on a chalkboard in New York, where I am. We call them trial exhibits, and they're just basically, there are companies that make them for you. They're on that giant poster board, like you have to go out and find sometimes for your science fair presentations for your kids, and drive around to 17 stores before you could find them because they're all out of stock. Except they're not the trifold boards. They're like, you know, big poster boards. Trial exhibits, they call them chalks. Apparently you need permission from the court to do that. And so they're asking for permission to present a demonstrative exhibit based on Christina Hanley's testimony. Not the chalks, not the chalks. It's like a foam board. Yeah, it's like a foam board. Cop's daughter, thanks. Dollar Tree has them cheap if you can find them, except for when it's science fair time. Good luck. Anybody who knows knows. Hold on one sec. I need a drink. Christina Hanley is part of the Massachusetts State Police Crime Lab. She testified with regard to the glass that was found. And I think she also is the tech, or the crime scene services tech, who went to inspect the car in the Sally Port. She may have been also testifying not just about the glass, right, but also maybe about the hair. She also testify about the apparent hair on the bumper. Okay. So here's what they're saying, that they would like to present the attached demonstrative exhibit, or chalk, to the jury. This chalk is necessary to clarify critical evidence and will aid the jury in understanding the testimony presented. And we've talked about this a lot, how we are hoping that this time they use some PowerPoints, that they use some sort of visual aid for the jury. Because if we are going to rely on the jury to rely on their notes, it's a recipe for disaster. This was a 10-week trial last time. Some of the jurors took a lot of notes. Some of them took none. Massachusetts is also insane in that they don't allow readbacks of testimony. And I don't know if it's the entire state of Massachusetts, or just this judge, or just a function of the fact that the court reporters there speak into what looks like an athletic cup instead of using the stenography machines that I am used to in New York, where it comes out in like a ticker tape. And it's easy for the court reporter to just come back into the room and read back portions of testimony. I don't know what their reasoning is for it, but I'm going to submit to you, as I have a million times before, that not allowing readbacks of testimony is going to lead to jurors relying on false memories and bad notes, and notes that they may have taken wrong, and notes that they maybe can't read, and arguments in the jury room about people's notes saying different things. A lot of people are visual. A lot of people need visual evidence. It is much more interesting when you can use such things as that. And so I don't remember if last time she said no chalks, but we definitely did see things put on the overhead projector. So there's that. Here's the factual background. Ms. Reed is, accused of these crimes. We know all of that. And then they say, on January 29th of 2022, Mr. O'Keefe is captured on video surveillance footage leaving Waterfall Bar and Grill with a cocktail glass from the bar in his hand. The Commonwealth claims that this glass remained in Mr. O'Keefe's possession at the time he arrived at 34 Fairview Road, and was broken in the early morning of January 29th, 2022, outside the Albert residence after being struck by the taillight of Ms. Reed's vehicle. Oh, I like that. A little snarky. He's only struck by the taillight. Over the course of several searches, law enforcement recovered numerous pieces of glass from the yard outside of 34 Fairview Road and the rear bumper of Ms. Reed's vehicle. The source of the glass recovered from the bumper of Ms. Reed's vehicle and the lawn of 34 Fairview Road is material and relevant to this case. At the first trial, Christina Hanley, a forensic scientist at the MSP Crime Lab, testified for the Commonwealth about the pieces of glass recovered from the crime scene and from the bumper of Ms. Reed's vehicle. And then they are citing a portion of the transcript. This testimony lasted more than an hour and spanned 37 pages of the trial transcript. Throughout her extensive testimony, Ms. Hanley discussed 16 distinct pieces of glass recovered from 34 Fairview Road and the bumper of Ms. Reed's vehicle. These 16 pieces of glass originated from 4 separate sources. Some pieces of glass came from the same source, meaning that they were originally a part of the same object. Ms. Hanley's testimony is very intricate and difficult to follow without some sort of visual aid. Praise be. Praise be. So difficult to follow. And they go on to say, during trial, Ms. Hanley herself frequently needed to refer to her notes and request that counsel repeat questions to keep the various pieces of evidence she was discussing clear. To remedy this problem, the defense proposes the use of a demonstrative aid consisting of one chart spanning 1 page, containing representations of all recovered pieces of glass and graphics depicting which pieces came from which source of glass. The proposed chalk tracks directly with Ms. Hanley's testimony and report. This is imperative and genius because I did not even remember that the glass was from 4 different sources. Did you? I remember that the glass on the bumper did not match the cocktail glass, but I do not remember that it was from 4 different sources. The chalk starts by identifying 4 basic categories based on where the pieces were recovered from and who they were brought in by. Oh, that'll be great. Each group of pieces is called an item. These items are 1, item 3-2, the base of the cup recovered from the scene. I don't know why they keep calling it a cup. I think it's because she called it a cup in her testimony and in the evidence logs, but that is not a cup. A cup to me looks like a mug. A cocktail glass is a cocktail glass, but that's just me. So the first one is the base of the cup recovered from the scene. The second one is item 3-3, which is 5 pieces of glass taken from the bumper of Ms. Reed's car, viewed by the laboratory as 1 item. The third group of glass is item 7-12, 9 pieces of glass taken from the scene by Trooper Buchanan, viewed by the laboratory as 1 item. And the 4th batch of glass is item 7-14, a single piece of glass taken from the scene by Trooper Proctor. I don't think there's any chain of custody for this stuff. I don't know if there's any indication of when this stuff was found, but I know what we do know is that Michael Proctor was not at 34 Fairview on January 29th of 2022. And if you watched the hostage video, you know what I'm talking about. So many people are confused, by the way, about that. So let me just clarify the record for those of you who watched Peter Tragos's Lawyer You Know video. I think it was yesterday, maybe, on the Michael Morrisey, what I dubbed the hostage statement, because to me, it looked like he was reading a script and someone off camera had a gun to his head, like maybe one of the Alberts or McCabe saying, you got to read this. In my opinion, only hypothetically. And he did it in his conference room in front of a whole bunch of books, a whole bunch of law reporters that were upside down, not even in order. It was a video statement that he recorded. There was no press in the room. And then he just released it on YouTube. And that was right after the gag order was denied the first time, if you recall. That video was released by Michael Morrisey in August of 2023. A lot of people think that that's a new statement. It is not. I just want to correct the record on that. It is not. It is just that Peter Tragos had never seen it before. And so therefore, he did a video on it. Okay. Okay. Got it? Each smaller piece of glass within items 3-3 and 7-12 has an additional lettered label referencing the individual piece itself within the broader item. Item 3-3 contains the sublabels A, B, C, D, and E, each letter representing an individual piece of glass. These sublabels are the same as those assigned by Ms. Hanley in her testimony and in her lab report. Similarly, the 9 pieces of glass in item 7-12 are labeled A, B, C, D, E, F, and then I, K, L, skipping letters G and H, as was done in Ms. Hanley's testimony and in her report. Oh, where did G and H go? Did G and H magically disappear in the magical mystery Sally port? Hold on, 7-12 was 9 pieces of glass taken by Trooper Buchanan. 1, 2, 3, 4, 5, 6, 7, 8, 9. Well, there's 9 pieces there, but I don't know why G and H were skipped. I don't want to think about that too long because it'll hurt my head. For each individual piece of glass, the chart includes a graphic next to the corresponding label based on which other pieces of glass that piece, quote, matched. Oh, I love this. I love this so much. The graphics in the columns next to each other, next to each label, correspond directly with Ms. Hanley's testimony, particularly the testimony on pages 75 and 76 and 90 and 92 of the June 5th, 2024 trial transcript. So for those of you, if you're watching, like Boozy Beauty, Olivia Nile, Lana, Del Turtle, all of this information is right here. If you want to go back and pull Christina Hanley's testimony, that's the date, June 5th, 2024. And now it's a little bit set out here. Who discovered what and what each piece may relate to. The graphics in the columns next to each label correspond directly with Ms. Hanley's testimony. I said that already. Each sublabel has a graphic next to it. Said that already. Through these graphics, the chalk summarizes Ms. Hanley's conclusions into a simple chart, which Ms. Hanley confirmed was an accurate representation of her testimony. Argument. To assist the jury in visualizing Ms. Hanley's granular and essential testimony, the defense proposes the attached demonstrative exhibit, or chalk, to aid the jury, which is attached here too as Exhibit A. A demonstrative exhibit is something presented to the jury to help them better follow and understand the evidence, but is not evidence itself. And then they cite the Massachusetts General Evidence Rule. Demonstrative exhibits can take many forms, including live demonstrations, charts, and even literal chalk figures on a blackboard. It's probably where it got its name. Demonstratives are particularly useful where a party presents complicated testimony that may be difficult for a jury to understand or visualize. These sorts of aids are appropriate where, number 1, they are relevant. Number 2, they are not more prejudicial than probative. And 3, they sufficiently resemble the actual event so as to be fair and informative. Or they are fair representations of the facts the chalk aims to clarify. Finally, the court has broad discretion in determining whether to admit a demonstrative aid. 1, the proposed chalk is highly relevant. Ms. Hanley's testimony is clearly relevant, whether any of the glass on the bumper matches the cocktail glass at the scene or is from some different unidentified source, and goes directly to whether the evidence in this case supports that Ms. Reed struck John O'Keefe or the cocktail glass in question. The relationship between the other pieces of glass are critical to understand the scene. Yeah, also because, no scene photographs, no measurements, no chain of custody, no logs. Therefore, the chalk which summarizes Ms. Hanley's testimony about this glass is also highly relevant, especially given that the chalk provides much needed clarity to an otherwise complicated issue. Without a chalk, the jury would need to be able to either accurately record or memorize the source of each piece of glass and each piece's relationship to all the other pieces in order to make sense of Ms. Hanley's testimony. The complexity of this testimony is underscored by Ms. Hanley's frequent references to her notes and requests for counsel to repeat questions. So yeah, she couldn't even keep it straight. How is a jury supposed to make sense of it if she can't keep it straight without looking at her notes and asking the attorneys to repeat their questions? Particularly questions about the relationship between these pieces of glass. Of course, referencing notes and requesting the repetition of questions is permissible and even preferable to ensure that the testimony is accurate. However, if a lab expert has trouble keeping track of the labels of evidence that she analyzed herself, surely the jury would have even more trouble making sense of this critical evidence, making the chalk not only relevant, but essential. Point 2, the chalk would not prejudice the Commonwealth. Any prejudice that may be argued to stem from the chalk is far outweighed by its probative value. Keep that in mind, because that is the standard for admitting evidence. It is whether the evidence is more probative than prejudicial, whether it will help the jury more than it will prejudice one side. And that is a weighing test that is up to the judge. The chalk does not present the chalk does not prejudice the Commonwealth in any way. Rather, the proposed chalk would be highly probative in relation to Ms. Hanley's testimony, which would otherwise require jurors to memorize and differentiate the titles and sources of various pieces of glass with labels that closely resemble one another. It is merely a depiction of which glass pieces match others and a visual representation of Ms. Hanley's live testimony. Given that the chalk corresponds so closely with Ms. Hanley's testimony, a witness for the Commonwealth, it's difficult to see how the chalk could be remotely prejudicial. Right. They can't argue to not allow this exhibit in, especially if they fact check it for themselves, because doesn't the Commonwealth want a fair trial too? Well, we know that they do, because Hank Brennan talks about it often. The Commonwealth is entitled to a fair trial. I don't remember seeing that in the U.S. Constitution anywhere, but he seems to believe it. And so based on his own representations, he should be happy that the defense would like to order and pay for an exhibit to be presented at court for the Commonwealth's own witness to reference and to help the jury. Unless, of course, the Commonwealth's whole point is to confuse the jury and throw a whole bunch of spaghetti at the wall to the point where they don't know what's up or down or inside out. Am I right side up or upside down? Because I think that's what they did last time. I mean, we know that's what Lally did last time, because how many weeks was it until we even found out how the Commonwealth thought John O'Keefe died? Weeks and weeks and weeks and weeks. Even if the court finds that there is some prejudicial tendency to the proposed chalk, it is far outweighed by probative value. The Supreme Judicial Court of Massachusetts has been liberal in allowing demonstrations and chalks, even where there is potential for extreme prejudice. In Commonwealth versus McGee, well, that's not Penny McGee, because this is where the defendant was accused of murdering his partner in front of their 6-year-old child. The SJC upheld the allowance of a physical demonstration by that child, then 10 years old, of the position in which he saw his mother on the couch when she was killed. Oh, that's very sad. In support of this decision, the court highlighted that the testimony about the decedent's position on the couch at the time of her murder was crucial in determining whether the premeditation element of murder in the first degree was met. Given that a live demonstration by a child of the position his mother was in when she was killed was permitted as more probative than prejudicial, this proposed chalk, which simply depicts Ms. Hanley's testimony, is certainly more probative than prejudicial, if prejudicial at all. Point 3. As described in detail above, the proposed chalk directly mirrors Ms. Hanley's testimony fairly and accurately. And mirror is also an interesting choice of words, because isn't that how Yuri Buchanan described the inverted Sallyport video? Well, yeah, I mean, it's like accurate, except, it's like when you look in a mirror and everything is just, backwards. These are like little Easter eggs. These are like little Easter eggs that I'm going to point out as we go through these papers. Oh, where's my red pen? I don't have time to red pen today. We got too much to get to. As described in detail above, as seen in the chalk itself, the chalk is merely a summary of Ms. Hanley's testimony. 4 categories displayed in the chalk. The 4 categories, the labels used in the chalk, and the connections between each piece of glass are all drawn directly from Ms. Hanley's testimony. In fact, during the first trial, Ms. Hanley was shown this exact chalk, which she confirmed on the record was an accurate reflection of her testimony. Well, if she was shown it, why wasn't it allowed in? I don't remember. But anyway, I digress. Conclusion: without the chalk, Ms. Hanley's testimony will be exceptionally difficult for the jury to follow, which would seriously detract from the important evidence Ms. Hanley will present. Given the great relevance of the contents of this chalk, its lack of prejudicial tendency, and the tight relationship between the chalk and Ms. Hanley's testimony, the proposed chalk should be permitted. So please, 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 Judge Canoni, please allow us to make things easier for the jury. XOXO, Alan Jackson, Elizabeth Little, David Yannetti. We're gonna do, this is my executive decision here. We are going to do questions in between so that they're a little bit more timely. Thank you, Moon Goddess, for your super sticker, and Mrs. Bouquet for your super sticker. Isabel says, hi, Melanie, can some luck please fall Karen's way? Well, you're watching all the way from New Zealand, and I think you've been watching this long enough to know that we just don't know what's going to happen. But you know what? We have a magic 8 ball for that. Will some luck fall Karen's way? Hang on. It says, and yes, definitely. For real. That is what the magic 8 ball says. Yes, definitely. Thank you for asking, Isabel, and for your super chat. Canoni's baloney. I swore I wasn't going to change my name, but I've been driven to it. Couldn't stand this baloney without us. Thank you. Thank you, Jadzia, for your super chat. And Jeanette became a member. Welcome, welcome. And Michelle, thanks for your super sticker. Isabel says, this is an obsession about finding Karen guilty. Many people feel that way. You are not alone. Mo, thanks for your super sticker. Elf gifted a membership. Thank you, Elf, for being so generous. Can Mark Bettero help the defense team now that he's not on it? I will not be opining on that. Thank you so very much, though, for your super sticker and for many, many other people who keep asking me that question that I cannot answer. Thank you. Kevin, thank you so much. I heard you talking about Buchanan and the pronunciation of his name. Please tell me you heard what Jen McCabe called him on the stand. I do. I don't. That's one of the blocked words in my chat. I did not know what that was. And I don't know. Am I like naive? I don't know. But if you don't know what it is, don't Google it. Thank you so much, though, for paying $5 to make me try and get me to say it, which I won't. Isabel, I wonder if Melanie will get as snarky as the other time. Thank you. It made you feel better? Oh, thanks, Isabel. UMass Debate became a member. Welcome. Kevin said, oh, sorry, it was Julie, not Jen. You're right. It was Julie. You were correct. Thanks again, Kevin. Erica Jackson wisely used cup to differentiate cup from glass, which was being used to describe all the items and one source. Thank you, Erica. See, he's very, very smart. He used that to differentiate it from glass. I don't know if those were his words, though, or if those were her words, and I don't recall, but I will say, I will give him credit for it if you say so. Thanks for your super chat. Jonna, thanks for your super sticker. Jadzia, I hope they'll differentiate between glass and polycarbonate this time and clarify how hard it is to smash polycarbonate rather than just crack it. Well, let's see. We got to keep reading. Thank you for your super chat. Can the defense file motions requesting that the jury be allowed to request and review testimony during deliberations? If that is something that is permissible under Massachusetts law, it is something they could ask for. And if it is something that is not permissible under Massachusetts law, they can't ask for it. If it's something that involves judicial discretion, they may be able to. But I think with the system that they have, which is like an audio system, because it's not, it's not so easy to just pull up a ticker tape, let's say, for lack of a better term, and read it back. It would have to be listened to by the court reporters. So I can't opine on that because I really don't know with regard to the system that they use in their courtroom, whether that is even possible. But thank you so much for the question. Okay, so now we are on to 559. 559. And this is defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. And this is a long one, so everyone get your drink or I need a sip because I'm getting parched already. Here, the defense is asking to exclude any references to the irrelevant, inadmissible, and prejudicial events that purportedly transpired in Aruba on December 31st of 2021. Yeah, the Sullivan sisters. In my opinion, that was highly inflammatory, highly prejudicial, not necessary, and ridiculous, because last time that was the Commonwealth's motive. Karen Reed was so jealous from something that happened on that 60-person trip to Aruba that she intentionally backed her car up 24.2 miles an hour, 60 feet in reverse, and killed John O'Keefe on purpose because of her extreme jealousy about Marietta Sullivan's behavior in Aruba, and that she may have walked into the lobby and seen them, I don't know, canoodling. And then you remember Marietta Sullivan's testimony where she just, she called Karen Reed some pretty nasty names, dropped the F-bomb a couple of times. And I would never make out with him. He was like an uncle to me. A lot of people have their own opinions on that. As grounds for this motion, the defendant states that the proffered evidence is not relevant to any material issue in this case. Oh, and then also what happened after that is that Karen agreed to apologize for the incident and agreed to pay for a portion of Marietta Sullivan's room, I think, in Aruba, and also picked up a dinner tab when like at least 10 of them all went out to dinner together when nobody was looking. She picked up the tab. Yeah. So that generous woman is the one who they allowed all of this ridiculous testimony to come in about. Should the court find that the evidence is relevant, any potential probative value of the proffered evidence is outweighed by the substantial risk of unfair prejudice to Ms. Reed. And that's what we're talking again, the weighing test. Is the probative value outweighed by the prejudice? And here they're saying no, the prejudice outweighs the probative value. It's not going to help the jury decide anything because it's irrelevant. And it's not relevant to any material issue in the case. Factual background. Ms. Reed is accused of the following crimes. We don't need to read those every single time because we all know what they are. The defense suspects that the Commonwealth will again seek to admit testimony regarding a completely irrelevant verbal argument. This is a cold read for me, so I was just guessing. Between Ms. Reed and a woman named Marietta Sullivan, which occurred in Aruba on December 31st, 2021, for the sole purpose of trying to assassinate Ms. Reed's character in the eyes of the jury. At Ms. Reed's first trial, every single witness unequivocally testified that there was no history of violence whatsoever in Ms. Reed and Mr. O'Keefe's relationship, that the two of them were in good spirits on the night of January 28th of 2022. And we remember that because we went over all of the initial witness statements from every single person who was at the waterfall with them. And they all said they were getting along great. They were not fighting. Neither one of them appeared to be drunk at all. And then, of course, you know, they all changed their testimony when they got on the stand. With regard to that exact issue, but with regard to many other issues. Hold on one sec. Despite this, the Commonwealth repeatedly elicited inadmissible testimony regarding a verbal incident that occurred in Aruba 1 month prior between Ms. Reed and a third party, which had no logical relationship to the crimes charged. The Commonwealth has no reliable evidence to suggest that the Aruba incident had anything whatsoever to do with John O'Keefe's death a full month later on January 29th, 2022, or that this remote and isolated incident was even a point of contention in Ms. Reed and Mr. O'Keefe's relationship after that trip. Right, because, you know, they had a total phone extraction of both Karen and John's phones There were no text messages in there that said, I'm still pissed about what you were doing with Marietta when I walked in on you in the lobby. There was no mention in any of their text messages for the month following. And because you can bet that if there were, the Commonwealth would have had them admitted into evidence. At the first trial, the Commonwealth called Laura and Marietta Sullivan to testify about a highly inflammable incident in which Ms. Reed apparently got angry at another woman, not the decedent, meaning she got angry at Marietta Sullivan, not John, because she purportedly believed that Mr. O'Keefe had kissed that woman. The Commonwealth intentionally admitted this prior bad acts and character evidence for no reason other than to sully Ms. Reed's character. There's another Easter egg. All the Sullivan sisters do was come in and sully Ms. Reed's character in the hopes that the jury would indict her based on the fact that she was, in Marietta Sullivan's words, an a-hole. At trial, you two might not like that word. At trial, Laura Sullivan admitted that she was not president during, she definitely was not president, but Laura Sullivan admitted that she was not present during this verbal exchange between Marietta Sullivan and Ms. Reed. So her testimony about the New Year's Eve 2022 incident in Aruba is almost entirely comprised of inadmissible hearsay. Despite this court's limiting its instruction about bad character and propensity evidence, the Commonwealth was permitted to elicit prejudicial testimony from Laura Sullivan that Mr. O'Keefe purportedly called Ms. Reed crazy and that he had insinuated that he was unhappy in the relationship. Yeah, you remember all of that nonsense? Marietta Sullivan's trial testimony was also extremely prejudicial to Ms. Reed. Her retelling of the verbal dispute with Ms. Reed was not probative of any material fact or element in the case, and it culminated with Marietta telling the jury decidedly that Ms. Reed sucks. That's what it was that she said. Ms. Reed sucks. She sucks. As set forth herein, this evidence must be excluded. Remember too, those of you who are with me during all of the pretrial shenanigans for the first persecution of Karen Reed, that this was one of the reasons that the defense moved in the first trial to dismiss the indictments. One of their arguments was that the Sullivan sisters were brought in to testify in front of the grand jury, and that was highly inflammatory, extremely prejudicial, not probative of anything. So dismiss the indictments. It was just one of their arguments. And of course, that motion was denied. And of course, they were then allowed to testify at the trial. But again, is it more probative than prejudicial? I submit to you, no, it is way more prejudicial because they're trying to make Karen Reed look like a crazy, jealous person who decided to mow down her boyfriend and leave him to die in the cold because of something that happened a month prior. And yet there was no evidence or conversations between John and Karen in the month following that would evidence in any way that she was still mad about it. She called her a bitch as well. Yeah, she might have. Okay, I don't know how to, that maybe that's your television? Bell South says its audio is working on cell, but not TV. That would have nothing to do with my settings and maybe your TV. Maybe you need to turn your TV off and turn it back on. Thank you. Bell South. Bell South sounds like a phone company. Sounds like a broadband connection. Yes. Yes, Z, remember that? Laura Sullivan was smiling and waving at the camera when she was in the courtroom at one of the post-trial hearings, right? Or one of the new pretrial hearings, right? Haas Long to Sully in Aruba. Well done, Greg Lake. Well done. Well done. Here's the argument. The Aruba incident constitutes inadmissible prior bad acts and character evidence, and any potential relevance is outweighed by the risk of unfair prejudice to the defendant. Ms. Jim Marson says their testimony made me believe that John had an issue with alcohol, unfortunately. Right. And those who know, and may be able to piece that out. Those who don't know might think she's a jealous, crazy person. But I know what you're saying. Jim Morrison's why people are strange when you're a stranger. Faces look ugly when you're alone. Women seem wicked. We can go on with it. Roadhouse Blue is another favorite by the Doors. All right. Motions in limine concerning the introduction or exclusion of purportedly relevant evidence are properly made and considered before and during trial in advance of the evidence being offered. The purpose, for those of you who were wondering before, we're going to quote from a Massachusetts case right here. The purpose of a motion in limine is to prevent irrelevant, inadmissible, back to one. The purpose of a motion in limine is to prevent irrelevant, inadmissible, or prejudicial matters from being admitted into evidence. And in granting such a motion, a judge has discretion similar to what she has when deciding whether to admit or exclude evidence. Okay, so motions in limine can be for both things, to either admit evidence or to exclude evidence. The first one that we watched about the chalk was to admit the chalk. This one is to exclude the testimony of the Aruba sisters or the Sullivan sisters. It is a fundamental rule that the prosecution may not introduce evidence that a defendant previously has misbehaved, indictably or not, for the purpose of showing his bad character or propensity to commit the crime charged. Although this type of evidence is sometimes admissible for other relevant purposes, such as to prove a common scheme, pattern of operation, absence of accident or mistake, identity, intent, or motive, these exceptions are not without limitation. So this is pretty much black letter law. Prior bad act testimony is usually never admitted if the only reason that it's being offered is to show that she's a bad person. And so therefore, because this happened, that makes it more likely that she would have mowed her boyfriend down. But let's say if you are involved in, like, say you're being indicted for like check kiting or something, bank fraud, and you had done this in the past, it may be admissible to show a lack of truthfulness. Or if you had if your crime involved something that has to do with truthfulness and you had prior bad acts of being untruthful before, it could be admitted for the sole purpose of that, to prove a common scheme. I'm trying to use layman's language as much as I can, but to provide a common scheme, pattern of operation, accident or mistake, absence of accident or mistake, identity, intent, or motive. Sometimes it's admissible. And if the Commonwealth wants this stuff in, they're going to have to come up with a pretty good reason why. Although I'm pretty sure they made this motion before the last trial and it was still allowed in. Similarly, although evidence of a hostile relationship between a defendant and his spouse may be admitted as relevant to a defendant's motive to kill the victim, such evidence should not be admitted if it relates to events which occurred at a time that is too remote from the killing, right? They made this argument last time too. They said it was a month prior. It wasn't like it was the day before. And then they cite some cases. Temporal remoteness is not an exercise in line drawing, rather a reviewing court focuses on the logical relationship between the prior bad act evidence and the crime charged. Here, there is no such logical relationship. In order for evidence of a prior hostile relationship to be relevant to a defendant's motive to kill the victim, the evidence must actually establish a prior hostile and violent relationship between the victim and the defendant. There's nothing violent about what happened in Aruba. This was an argument that Karen had with Marietta Sullivan. She didn't even have an argument with John. Unless the niece and nephew testified that she did at some point when she came back into the room, but the Sullivan sisters did not testify to that. And it was only Marietta Sullivan who testified to the fact that Karen was mad at her, not at John, right? And then they go on to cite a whole bunch of cases and what those cases stand for and the examples therein. But I can't read all of them because we have so much to read that I'll just scroll through that slowly in case you want to come back later and you want to read the cases and you want to fall into a rabbit hole. And then they say this case law is not comparable to this incident during which Ms. Reed briefly became angry with another woman, not the decedent, because she believed that Mr. O'Keefe had kissed that woman. There was zero physical violence here, no threats of violence, no police involvement necessary, and absolutely no history of violence in Ms. Reed and Mr. O'Keefe's relationship. And that is all true. Moreover, even when this type of evidence might be relevant for some limited purpose, the evidence must be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant. And then there's a very long footnote here. And I'll leave that there in case you want to come back and read it later. Massachusetts courts have long held that where evidence of prior bad acts is relevant for purposes such as intent or motive, it should be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant, even if not substantially outweighed by that risk. Here, testimony by Marietta Sullivan that Ms. Reed became angry with Marietta, not the decedent, on New Year's Eve on 2021 because she believed that Marietta had kissed her boyfriend, John O'Keefe, is simply not probative as to whether Ms. Reed had an intent to murder John O'Keefe on January 29th of 2022. This event was remote in time and was clearly not an issue between O'Keefe and Reed on the night in question, as evidenced by video surveillance footage from the Waterfall Bar and Grill on the night in question, right? Because they were cozy. They were cozy, they were huggy. In fact, I want to point out one of my favorite witnesses was Mrs. Kolakethis and Mr. Kolakethis, who were with them at the waterfall. But I think the CF McCarthy's video also showed them huggy and canoodling. Karen and John, that is, not John and Marietta. Don't get confused. Mrs. Kolakethis said, or Mr. Kolakethis, I can't remember which one, but they were so lovey-dovey in the bar. I think it was Mr. who said that when they got home, his wife said to him, "Why can't you be like that with me?" Right? I love the Kolakethises. They were amazing. As evidenced by the video surveillance footage from the waterfall on the night in question and the testimony of 8 witnesses, all of whom agreed that the couple appeared happy and in good spirits. "11 witnesses testified," I think it was 11, that they did not see a body on the lawn, and 8 witnesses testified that Karen and John were real happy that evening together and in good spirits. There's no logical relationship between the, and also I think 11 people said that guy never came in the house. Yeah, I think that's what it was. There's no logical relationship between the Aruba incident and the crime charged. The Commonwealth's attempt to characterize this misunderstanding as some sort of turning point in Ms. Reed and Mr. O'Keefe's relationship is off base and unsupported by the evidence. And I want to just ask, and this is just a random question. You don't have to answer it if you don't want to, ladies. Ladies, maybe, and gentlemen too. How many of you have ever been in a relationship and in a situation where something like this happens and then you bring it up forever after it happens? Right? So I think it would be fair to bet that if this was still bothering her, they would have had some sort of conversation about it in text message. "Oh, really? How's Marietta? Oh, really? Are you going out with Marietta?" Like, there would have been some sort of continuing conversation about it, especially within the 30 days right after it happened, right? People bring it up all the time. They never forget. Yeah, I can forgive you, but I can't forget. So think about your own personal experiences, right? Women do that. We do not. I'm guessing, are you a man, Daily Quick Bites? Women do that. We do not. Oh, men do. They do too. Oh, really? How's your boyfriend? How's your boyfriend? You like that guy's picture on Facebook? I saw you loved it. You loved it. Really? Do you love that guy? Yeah, it would have been brought up for life. Right? Listen, when a jury comes to sit and hear a case, they don't leave their common sense at the door. They don't leave their personal experiences at the door. And maybe that's got to be hammered home a little bit too. Because it's a human thing, not a woman thing. Thank you. Thank you, Life on Makeup, for saying that it is. Jealousy is ugly, and people bring it back up. They will bring it back up. And if she didn't, I think that speaks volumes as to how much this incident meant to her. The sole purpose of the Commonwealth's attempt to admit this evidence is to sully Ms. Reed's character again with the Easter eggs by allowing Marietta Sullivan to testify that Ms. Reed sucks. If we are to believe the Commonwealth's best evidence, i.e. that Ms. Reed said, go F yourself, go duck yourself, to Marietta when she temporarily believed that she observed Marietta kissing her boyfriend on New Year's Eve in Aruba. I mean, look, many of us, what is the worse than that? Worse than go duck yourself. That evidence is simply not probative of a motive to murder Mr. O'Keefe more than a month later when the parties were, by all accounts, in good spirits. In order for there to be a logical relationship between the prior bad acts evidence and the crime charged, as required by Commonwealth v. Peno, the jury would need to believe that Ms. Reed reacted with a verbal go F yourself or go duck yourself when she believed she had observed adulterous behavior on December 31st, 2021, but then subsequently flew into a murderous rage a month later when this event was remote in time and not the subject of any arguments on the night in question. This type of reasoning defies logic. It also strains credulity. Ms. Reed's short-lived anger was not even directed at Mr. O'Keefe, and her apologetic conduct after the incident demonstrates that she knew the kiss could have been a misunderstanding. The only reason for the admission of this evidence is to sully Ms. Reed's character and prejudice the jury against her. Ms. Reed reasserts here that this evidence has no probative value regarding the crimes for which she's been indicted. However, even if the court finds that this evidence is relevant, any marginal relevance of Ms. Reed's temporary belief that O'Keefe kissed another woman 1 month prior might have in terms of evidencing a hostile relationship or intent to murder is far outweighed by the prejudicial, inflammatory effect it will have on the jury. You may remember that they made this motion before the first trial. The difference now is that now they have the benefit of what these women said on the stand, and they can now point to direct in-court testimony that they didn't have before the first trial. 2, the Commonwealth must be prohibited from calling witnesses to testify to inadmissible hearsay for the purpose of attempting to show a hostile relationship. And then they go on to explain Massachusetts law with regard to that point. Massachusetts courts have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. The Commonwealth's argument in prior proceedings that this testimony is admissible in order to show the defendant's state of mind is misguided. That was her ruling on the first case, on the first motion before the first trial. Yeah, I'm not going to admit it, for its truth. I'm going to admit it for evidence of her state of mind because it was a month prior. Again, the events in Aruba took place a month prior. Oh, look, they said that. A month before John O'Keefe's death, and there's no evidence to suggest Ms. Reed was still upset about it on the night of January 28th, 2022. Unless they're going to come in waving some papers or some recordings of Gretchen Voss or one of the other outtakes of one of the other interviews where she says, I was still mad about it. Here, testimony by Laura Sullivan regarding the irrelevant and inherently prejudicial Aruba incident must be excluded because this witness has nothing to testify about other than the inadmissible hearsay and prejudicial character evidence. So Laura Sullivan should be out. Indeed, during the 2024 trial proceedings, the Commonwealth chose to put Laura Sullivan on the stand to testify about an incident that she did not witness in Aruba on December 31st, 2021, involving Ms. Reed, Mr. O'Keefe, and her sister Marietta Sullivan. Laura Sullivan was also permitted to testify about her completely irrelevant negative impressions of Karen during the planning of the Aruba trip, i.e., that Karen told her she needed her own bathroom and that she didn't want to share a room with John's kids. Remember that? She thought she was a real bitch because she wanted her own bathroom. She needed her own bathroom and didn't want to share a room with the kids. Well, she also has Crohn's. Anybody who has Crohn's or knows someone with Crohn's knows that they like to have their own bathroom, and doesn't make her a bitch. The Commonwealth then elicited an additional inadmissible and prejudicial hearsay testimony from Laura, who told the jury that Mr. O'Keefe told her that Karen is crazy during a later conversation on the night of December 31st, 2021. And then on January 2nd, 2022, John insinuated that he was unhappy in their relationship. All of that was complete and utter duckin' BS. And I couldn't believe it came in, and yet it did. We were here with each other screaming about it. Footnote 2. Note, this unhappiness was allegedly communicated non-verbally and solely via Mr. O'Keefe's body language, namely a shrug and an eye roll. Really? Not only is this inadmissible hearsay, but it's also an interpretation of a gesture, not an assertion of actual words that Mr. O'Keefe said to Laura, and thus calls for speculation. No. She shouldn't be allowed to testify, in my opinion. But you know what? The judge doesn't care about my opinions. Notably, Massachusetts courts have long held that the omission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. Thus, all of Laura Sullivan's testimony regarding the Aruba trip constitutes prejudicial and inadmissible hearsay, which must be excluded. Conclusion: for the above reasons, Ms. Reed respectfully requests that this court exclude any reference to the December 31, 2021 trip or incident in Aruba. XOXO. Alan Jackson, Elizabeth Little, David Yannetti, and Bobby Alessi. And that was docket number 559 regarding the Sullivan sisters. Let's go back to the chat. Okay, what do we have here? Edward says, my favorite is Buchanan got super mad at AJ for mispronouncing it, and still, even the Commonwealth and everyone really still pronounces it wrong. Thank you, Edward. I don't really care how to pronounce it. I don't care if I'm pronouncing it wrong. Bobby Alessi's linguistic prowess. I would like to know what the Commonwealth is smoking. That could explain the upside down world we're in. Thank you for your super chat. Leona, do you think the courts will ever get sick of Chris Albert's crazy witness intimidation charges? That's rhetorical, right? Thank you for thanking me and for your super chat. Shannon, I will be on maternity leave during the trial. We'll be in all my glory watching you every day. Oh, congratulations on your new baby, or your new baby that's coming. Love you too, Shannon. Congratulations. Binging Crimes Not Cookies says, I have a feeling that Officer John O'Keefe did not die from hypothermia. We shall see. Thank you for all of your coverage. Thank you for your super chat. I would never try to make you say anything, Kevin. Kevin, I think you, maybe. Kyle lies. Has Proctor been put on a Brady list? There's been no determination of his status yet. And so I don't know if he's been put on a Brady list yet. I don't think so. There's so much information on this case that happens like every single day. So I don't think that he has. I know that the other defendants who have been who have cases in which Proctor was the lead investigator have been notified about him. And so, yes, I did see the video of the pizza shop. Yes, I did. Yes, and we know about those charges, and we know about the federal letters and all of that stuff. But unfortunately, we're not going to be able to get to that today because we have way too much stuff to go through on Karen Reed. And so I don't know. Kyle, thank you though. Judge Bev Stack Deck, thank you for your very $50, very generous $50 super chat. Says Judge Bev Stacked Deck says, I'm late, but didn't want to miss sending you some love. Oh, thanks. I love you too. Thank you with all of my heart. Thank you for tuning in and for your very generous super chat. Aaron became a member. Welcome, Aaron. And on top, thank you for another super sticker. You're amazing. All right, now we go to 560. Let me see. Let's see what we have here. Five 561. Five 64. Talk amongst yourselves for a second. It's 562. I think 562 is impounded. Okay, so now we move on to 560. Impounding is the weird word that they use in Massachusetts, meaning that it's sealed. In New York, impounding is what you do to a car. When you have too many parking tickets, they impound your car. This judge doesn't care about the truth. She can't handle the truth. Moving on to docket number 560. Docket number 560, which is defendant's motion to impound certain portions of defendant's motion in limine to exclude certain witnesses before and after testimony. So the defense team, Karen Reed's team, is asking the court for an order impounding portions of defendant's motion in limine, excluding testimony. So that's, I believe that's 560, and that's, 562, and that's why we can't see it. Okay. Namely, the portion of the motion referencing text messages that are subject to a protective order. Now they're being extra careful. Issued in connection with this case, an Exhibit A containing a copy of those text messages. Good cause exists for the impoundment of this information because it's subject to a protective order. In support of this request, Ms. Reed hereby submits 2 copies of this motion, an unredacted copy for the court file and a copy of the motion with all the text messages subject to the protective order so that the court can see them. XOXO, Karen Reed and company. So that is a motion to impound. It's 560. 561 is just an affidavit in support of that by Elizabeth Little, who says that we are in good faith making this motion to impound certain portions of that motion. We don't need to look at that. And then 562 is the motion. That is the one that's impounded. So we can't get that, but we can get 563, which is the redacted copy. So let's read that. This is defendant's motion in limine to exclude certain witnesses before and after testimony. Karen Reed and her team are asking the court to exclude certain witnesses from the courtroom before and after their testimony at trial in this matter. Rule 21, sequestration of witnesses in the Massachusetts Rule of Criminal Procedure states that upon his own motion or the motion of either party, the judge may, prior to or during the examination of a witness, order any witness or witnesses other than the defendant to be excluded from the courtroom. Citing Massachusetts Rule of Criminal Procedure number 21. The power of a judge to control the progress and within the limits of the adversary system, the shape of a trial is universally held to include the broad discretionary power to sequester witnesses before, during, and after their testimony. Citing a bunch of cases and the reporter's notes to Rule 21. Ms. Reed specifically requests that the court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their testimony at trial. Well. Bang. Bang, 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 bang. Let's read that again. Ms. Reed specifically requests that the court exercise its broad discretion, because she has broad discretion. Judge Cannoni has broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their testimony at trial. Certain exceptions, I will tell you this. There's a law called Morrisey's Law, spelled Marsy, and that is a law that allows certain witnesses, I don't know what they call it in Massachusetts, I might be thinking of Florida, but it allows certain witnesses to remain in the courtroom before and after their testimony, or at least after their testimony. For example, in the Turk case, I just saw a motion come in to allow Katie McLean's ex-husband, who is the father of her 3 children, to be in court with his children during or after his testimony with his kids. Morrisey's Law is a law that allows victims' families to be in the courtroom after their testimony. We saw that in the Ashley Benefield case, where Eva and cousin Tommy were allowed to be in the courtroom. None of these people are family members of John O'Keefe. None of them are. Let's go on and read the legal reasoning. As this court likely recalls, after they testified, members of the Albert and McCabe families proceeded to sit in the gallery with the O'Keefe family, facing the jury sporadically throughout the remainder of the trial, including closing arguments. Oh yeah, we didn't like that. Following trial, hold on. Exactly, Joanna. Thank you for reminding me. Just like Paul had that right, because he's his brother. That's right. That's right. Thank you, Joanna. And Erin too, as the sister-in-law. Although I don't think we'll see Erin during this trial. Following trial, a juror reported to Vanity Fair magazine that he or she felt it was utterly inappropriate that the Albert and McCabe families were able to stare down the jury from their position in the courtroom gallery. Yep, that's what they were doing. Oh, I can't wait for Gretchen Voss to be asked about that on the stand. No, she wasn't the Vanity Fair reporter. Who was that? Julie Miller? Never mind. Withdrawn. Julie Miller, there it is. I waited a second. One juror reported to Vanity Fair magazine that he or she felt intimidated by the Albert and McCabe families, calling their presence in the courtroom's small gallery facing the jury completely and utterly inappropriate. And that is also citing Julie Miller's Vanity Fair article. Noting that the Albert and McCabe families were substantial focal points of this trial, the juror noted how unbelievable it was that the families were allowed in to stare the jury down. And then this portion is redacted, the rest of the page. And then the beginning, first paragraph of the second page is also redacted. This was extraordinarily prejudicial to Ms. Reed. The alleged third-party culprits, Brian Albert, Colin Albert, and Jennifer McCabe, all sat in the gallery during closing arguments directly facing the jury. Oh, I love this motion so much. Which, according to at least one juror, was intimidating. I think was it Ronnie that said it was intimidating? I mean, I think Ronnie also said it was intimidating, and I don't think Ronnie was interviewed for the Vanity Fair article. But I could be wrong. But I think the first time he ever spoke out was when he spoke to Aidan Carney. Ronnie did say it, right? But I don't think that Ronnie spoke to Julie Miller, right? I think that Julie Miller is talking about female jurors, but I could be wrong. Thank you. Thank you so much. The hidden cam in Bev's court, a.k.a. Scott, a.k.a. 25 years on the job, NYPD, says, Scott, can I hereby dub thee kindergarten cop? Because somebody in somewhere, another chat I was in said that I treat my my chat like a kindergarten class. So can you be the kindergarten cop? Says keep the outside drama out of the chat. This includes personal and family situations. Thank you. We do not like to defame people in the chat, and we don't want to do that. So the hidden camera in Bev's court is hereby dubbed the kindergarten cop. Thank you. None of your business wants to know if he or she can eat glue. No, don't do that at home. Don't try that at home, kids. We try. We try, Ann Smith. If we don't try to laugh, we will be crying constantly during the coverage of this case. We will just be crying all the time. It'll be nothing but tears. I added some new songs to the playlist per your request. The playlist is linked below. But after I finish reading this motion, I will tell you what the new additions to the playlist are, because so many of you are so collaborative, and we have a Spotify trial playlist, and we keep adding to it for the re-persecution purposes. Paste is okay. Meeple Marcy Sketty Stain says paste is okay, but do not. Well, Play-Doh's okay too, because I think really there's nothing harmful in Play-Doh, and who didn't eat Play-Doh as a kid? Oh, and here's a case, Cassiano, which says purporting that an act need not be overly threatening to be considered intimidating. And Gardner, which says defining the threshold of intimidation as to what would instill fear in a reasonable person. Well, I don't know. You guys are all reasonable people as far as I'm concerned. Would you have felt intimidated in Brian Albert and Colin Albert, also known as Colin Albert, because Cosgrove renamed him Colin the other day during Aidan Carney's hearing and called him Colin Albert for at least 10 or 12 times. You're all reasonable people. Would you be intimidated? If you would be intimidated, raise your hand. Footnote 1, which says courts have recognized that when a witness or person stares down a jury, that can make the jurors feel timid or fearful. And then there's a case called Commonwealth v. Gordon, which says defining intimidation as making timid or fearful, inspire or affect with fear, or to put in fear for the purpose of compelling or deterring conduct. Intimidation by the aforementioned witnesses in the context of this case took the form of staring down. Commonwealth v. Womack, which says noting the juror intimidation during a trial where jurors were concerned to leave, as there were a lot of people just kind of staring down and making the jurors uncomfortable. Wow. I mean, that's two cases that are specifically on point. And you know how Judge Cannoni loves to follow Massachusetts law. And that is exactly what these two cases say. And I'm shocked. I used to say you could always find a case. There's always a case. There's always a case to support your position. We have seen some of the issues in this case. There just is not a case like this. The double jeopardy issue, as it applies to Karen Reed with multiple counts, there is not a case on point with that exact issue. There are cases where juries have been called back because of racial bias years later. It was that that murder trial that happened in Cape Cod. Her name is going to escape me. Is it Krista Worthington? And there was a man who was convicted of her murder. He happened to be like a garbage man. And that's not derogatory. He really was the garbage man. And later, it may have been years later, I don't remember how long later, the jury was called back in because it turned out that one of the jurors, Krista Worthington, look at me. I don't know. I feel like I'm losing my memory. Defendant was Chris McCowan. Thank you, Miss Dad. And then sometimes I can remember like the most random things. That's why I'm really good at Trivial Pursuit, because I have like all sorts of random knowledge. The jury was called back because it came out later that one of the jurors may have said something racial or made a racial comment in the jury room, and they were brought back. There's always a case, but these are specifically talking about staring down jurors. And so, I mean, rarely do you get cases that are as on point as these. As previously noted, an individual does not need to do actual harm in order for an act to be considered intimidation. Okay, so there's that. As the jurors heard through testimony, the Albert and McCabe families have deep connections and familial ties to multiple state police forces and local governments. In addition, Mr. O'Keefe, a Boston PD officer, was part of this tight-knit law enforcement community. By sitting with the family of John O'Keefe and continuing to face the jury for parts of the remainder of the trial, at least one juror felt intimidated by what he or she perceived as the Albert staring the jury down. Yeah. I mean, this is a good argument. There's cases that are right on point. Here, the judge's broad discretion to order the sequestration of witnesses before or after their testimony at trial. A defendant has a constitutional right to a fair trial to be decided by an impartial jury, free from intimidation and undue influence. Given that at least one juror reported feeling intimidated by the presence of certain witnesses towards the end of the trial, Ms. Reed respectfully requests that the court exercise its broad discretion to issue a sequestration order excluding Brian Albert, Nicole Albert, Colin Albert, or Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their witness testimony to prevent further prejudice to Ms. Reed. Conclusion: for the above reasons, Ms. Reed respectfully requests that this honorable court exercise its broad discretion to exclude all of those people that I just mentioned from the courtroom before and after their testimony at trial. XOXO, Alan Jackson, Elizabeth Little, David Unetti, and Bobby Alessi. I like this motion a lot. Here's Exhibit A, which is, totally redacted. Totally redacted. And B, which is totally redacted. And page 3, which is that. So we are not going to get to see this exhibit, but I want to go back and just see what it says that the exhibit is. Hang on. I don't know. I don't know what it is. And I don't want to guess because it doesn't really say. But we know that it's redacted. And so this motion number, this is number 5. I'm sorry, 563. I think I misnumbered it earlier when I said it was 565. It's 563 because my notes now say 565. And this is the motion in limine to keep all those people who are not family out of the courtroom. I like it. Yeah, Control F and search exhibit. The problem is these are PDFs and I don't think that works. Thank you though. Thank you for the hot tip. Back to the questions. Yeah, redacted probably because it had the juror's name on it. And also, hey, judge, you didn't call the jury back. You didn't want to call the jury back. You wouldn't call the jury back. So we're going to have to rely on the reporter's notes who talked to the jurors. And, is she going to say, I can't really say that they were intimidated because it's not firsthand information from those jurors. And another thing is that the Commonwealth said that they got emails from the jurors too after the jury, but they told them they couldn't remain anonymous. And so, I mean, I can in my head think of what her reasoning would be to not allow this motion, but I think it should be allowed. Hang on one second. I don't know. Mo Hippie Show Me says that it may be pictures of them that are blacked out. I don't think so. Because if it was just pictures of them in the courtroom that were on TV, we would have seen it all. But I mean, what will they do if they're not allowed to sit in the courtroom, go to the VFW hall and have a viewing party every day? I mean, they could do that. The Goodmans are here and they gifted a membership. Thank you so much. On top says, now we're cooking. Thank you for your super sticker, super chat. Sarah and Shaganara is here. She's an amazing person and an amazing moderator. I love you with all of my heart. I love you more. Orwellian unperson. What can us super concerned lay people do? So frustrated about the bias and unethical behavior. It's hard. My head is popping off daily. You're doing it. You're showing up. You're watching. Share the information out there and get other people interested in it. Make this a story that the world can't ignore. Vote in your local elections. I don't know where you live, but where I live in New York, judges are elected, not appointed. They're appointed in Massachusetts. Make sure people know about this. Keep showing up and being interested and listening. You are the eyes of the world. You are. And thank you for your super chat. Fanning's Follies. I was safety patrol captain in grammar school. I can help with your class. Oh, thank you. I would appreciate that. I'll need an AV squad. Thanks for your super chat. Donnie, how did the feds not find a darn thing wrong with this whole mess? Please help me understand because no one seems to talk about it. Nobody knows. Nobody knows, Donnie. We don't know if they're really finished with their investigation. We don't know what's coming down the pike. They could be done with their investigation, waiting to hand out indictments. We just don't know. If you sit and you worry about it all the time, it's just, you're never going to be able to figure it out. And so for me, the best advice that I can give you is that I think that worry is a wasted emotion. Half the stuff you're worrying about is stuff that already happened that you can't change. And the other stuff you're worrying about is things that you think might happen that might never happen. So worry is a wasted emotion. Focus on going out and making things happen instead of sitting home and waiting for them to happen. I just made that up. Great. Not that you do that, Donnie, but we don't know. We don't know what's happening. I'm not so convinced that it's totally over because why did the Canton PD is the only one who released a statement on that. Helena Rafferty's little, letterhead, she said, but she's not a Fed. What does she know? She also wrote a Post-it note on the evidence of the Sallyport video from January 1st of 2022 that said, this is how it records, no tampering, LOL. So really, is this the woman that we're going to trust with the information that the federal investigation is over? I personally don't know if it is or it's not. For me, it doesn't change Karen Reed's trial either way. It's just, if it is over and they have not found any evidence of what really happened to John O'Keefe, then there will never be justice for John O'Keefe. And that is the tragic part of that. Thank you so much, Em. You got your merch today? Congratulations. Yeah, I think it's 15% off again today. I think today's the last day. The merch link is in the chat, in the show notes. So if you are interested in getting merch today, I think is the last day for the 15% off. Let me just see. And just make sure you hit the coupon code at the top of the, it's like at the top of the banner. It says 15% off, but then you have to apply the code. Because I even ordered stuff for myself and then I forgot to apply the code and I was mad. But what are you going to do? Hold on. I just want to make sure I'm not giving you guys bad information. Which, of course, I can't find right now. So if somebody can check the link and just see if it says 15% off at the top, that'd be great. That'd be great. Thank you so much for your super chat. I appreciate you, Em. Deja Vu trial too. Beautiful day in Indiana. It's beautiful here in New York as well. Sun is out. It's 60 degrees. Spring cleaning. Would you like to come and do my house when you're done? Thanks for everything you do. Oh, thank you so much. Says she's never seen anything like Karen Reed and Turtleboy. It's scary. It is scary. It's scary for a lot of people who don't realize that corruption really does exist. And it's out there. And it's everywhere. And that is why more attention needs to be brought to this. People who are just starting to look at the trial now. Somebody sent me, there's a new attorney who started on TikTok watching the trial, and she is hilarious. She's hilarious. I can't remember her name right now, but she's so funny. She's on TikTok, and she's all into it, and she does really funny videos. I think her name is Miss McKinney, right? There's Ms. McKinney Esquire on TikTok if you're on TikTok, and so it's so great. Josh H says, vote in every election, not just federal, municipal, local elections are the most important to your daily life. You're right, Josh. Thank you for the tip. And for the 5, Ryan, if you were the defense attorney, would you ask to switch the O'Keefe and Reed family court seating? Yes, I would. And we discussed that during the Penny McGee trial, because Penny McGee's trial was in the same courtroom. It was a bench trial, and it was flipped. Penny McGee's family and friends were sitting where the O'Keefe family sits, and the victim's family and friends were sitting behind Penny McGee. And I found that to be a much more fair seating arrangement. And so it doesn't hurt to ask. And who knows, maybe that's in one of these 1,000 motions that we're going over today. Great question, Ryan. Thanks for reminding me, because I was going to bring that up. Piney Woods, thank you too. Document review is my favorite. Waiting for the second motion to recuse. Love to you in the chat. Thank you, Piney Woods. Screaming Mimi became a member. Welcome. Paul Ward, love all these motions. Just flood Hanky with loads of motions and make him sweat for his 225K. Free Karen Reed. Thank you, Paul. Thanks for tuning in from across the pond. I'll allow it. Says, if a hired expert witness, i.e. ARCA, wanted to bring in their own demonstrative exhibits, would a motion need to be filed for that as well? I believe so. I can't say I'm 100% familiar with the Massachusetts rules, but I believe so. Because I think, and you can correct me if I'm conflating cases, my friends in the chat, but I think one of the witnesses at the last trial wanted to bring in some sort of video. I think it was a Commonwealth witness, some sort of video about some sort of, was it Ian Whiffen? You guys, I mean, I can remember some things. Wanted to bring in a video about how he did something with the cell phone extraction. I think so. I think they did have to ask for permission. Thank you so much. I'll allow it. I don't know if she'll allow it. Kyle, therefore, do not be anxious about tomorrow, for tomorrow will be anxious for itself. Oh, I like that. Sufficient for the day is its own trouble. Thank you. Thank you so very much for the inspirational quote. I think that we all can use some. It was a live demonstration that he did. We can all use some inspirational quotes every day. Moving on. Let me see if I have do I have 564 yet? Let's see. Take a moment to hit the like button, would you, while we are grabbing all of these additional motions. Oh, I have 564, so now I need 565, 566, and 567. We're cooking with gas today, you guys. We are cooking with gas. Nothing like a chock-full day of Karen Reed motions to get you feeling good about what's coming down the pike, because they have an army. The army is here. Remember when we talked about the Alanis Morissette song, Right Through You? Because I think during one of Karen's interviews, they asked her if she was upset, that Paul O'Keefe was staring her down during the whole trial. And she said something like, I see right through him. And so, I think in song lyrics, and up came Alanis Morissette. Right through you, right through you. You didn't think I'd show up with my army and ammunition on my back. Such a great lyric. Miss McKinney, Esquire, apparently posted something that said, I'm watching Trooper Proctor and I'm going to need a day. And then she had some emojis. That's funny. Thank you, my friend, for sending that to me. All right, moving on to 564. Five, 6, 4 is defendant. Oh, I don't know. Something happened. Like I just glitched. Am I glitching? I felt like it just skipped. I'm on Ethernet. Is it YouTube? You know that if I swipe out or something, I'm always going to be right back. So we even have a username for that. It's called Melanie Little's Left Swipe in StreamYard. Because that sometimes happens when I'm on the mouse trying to do things, or the whatever this iPad, this MacBook tracking pad thing. Okay, good. Here we go. Docket number 564 for defendant's motion in limine for view. What do they want to do? They want to go to 34 Fairview again? Let's see. Yes, they say, and we would like this court to order that the jury be taken on a view of the alleged crime scene. Oh, I like that. The alleged crime scene. Here comes the army. They did it last time, and remember, they brought Karen's Lexus there so that the jury could look at the Lexus. And then Lally told the jury, pay special attention when you're looking at the Lexus. The link for shirts is in the show notes. Maybe if I could pin it in the chat for you if you want it. Hang on one second. There should also be a store tab in like my tabs somewhere. I don't know. Let's see. Tell me if this link works. I'll try and pin it in the chat. Let's see. It does. And today expires 15% off everything. There's a little pink bar at the top and it says redeem. So make sure you redeem the coupon. And you too can get your I Went to Cancun with Attorney Melanie Little t-shirt. And also there's a Stay Cool, Stay Kind, Stay Classy with free Karen Reed on it. Okay. Yes, they did paint the house at 34 Fairview. It is a different color now. It is a different color. Suze, you don't need to file them. I'm inundated with emails, but thank you so much for asking. 599. No, I've got them all. Thank you. Thank you so much. I appreciate you and your 5 and your constant support. Thank you so very much. Okay, now comes the defendant. They want the jury to go on a view of the alleged crime scene. They did it last time. Well, let's do it again. Ms. Reed specifically requests that the court order a view of 34 Fairview Road in Canton and the exterior of the 2021 Lexus SUV here and after the vehicle. And remember, Lally wanted them to look at the interior too. And he said, pay special attention to the center console. And then we really never found out what that was all about. I still don't know what was in the center console. Ms. Reed further requests that the vehicle be towed to the public roadway in front of 34 Fairview. Finally, Ms. Reed requests that the court permit Ms. Reed to attend the view, subject to any reasonable restrictions the court deems necessary. Refresh my recollection about whether or not she was allowed to go on the view the last time, because I may be conflating my cases. It may be a different view that I'm thinking of and a different case that we watched together, and the defendant was not allowed to go. General Law 234A provides that the court may order a view by a jury impaneled to try a criminal case. And yeah, she was not allowed last time, says Mindy. Okay. Maybe Murdoch was not allowed to go. Okay. Thank you. A lot of people say Karen couldn't go. I think last time they said, oh, it would be a security issue. And, we have to block off the street. And they had a whole bunch of excuses. Could they request a view from the inside house looking outside? Well, there's new people who own the house now. So I think that would kind of be an invasion of their privacy. And so, unless the new owner was on board with that, Jason, I suppose you could ask for it. It might be probative, but let's read the motion and see if they do. So thank you. Thank you so much for your excellent, excellent point. Ms. Reed states that permitting the jury to view the crime scene located at 34 Fairview and the vehicle at issue, i.e. the alleged murder weapon, would assist the jury in reaching a verdict. Allowing the impaneled jury to view the crime scene located at 34 Fairview Road will be particularly useful because the lawn appears to be much more expansive in photographs than it does in person. In addition, allowing jurors to visually inspect the vehicle will assist the jurors in assessing whether Mr. O'Keefe's injuries are consistent with having been struck by any portion of the vehicle. That's right. Although what is seen on the view may be used by the jury in reaching their verdict, In a strict and narrow sense, a view may be thought not to be evidence. Citing some case law. Properly speaking, no evidence should be taken or testimonial comments made during the taking of the view. Right. So the lawyers aren't allowed to make commentary. Becky Hill, the court clerk, is not allowed to come along and say, oh, look, this is where Alec Murdaugh shot everyone. No chit chat with the jurors. During a view, the essential features of the crime scene may be pointed out by counsel, it being permissible merely to point out to the jury marks, matters, and things, but not otherwise to speak to the jury. But remember, here we have no markers, we have no we have no measurements, we have no photographs of John O'Keefe's body laying in the snow. We have really nothing. So I don't know how much they'd be able to point out because, there's nothing. As with the decision whether to hold a view, the decision to allow a defendant to be present is within the trial judge's discretion. Ms. Reed respectfully requests that the court allow her to be present for the view, subject to any reasonable restrictions the court deems necessary. For the above reason, Ms. Reed respects that this honorable court allows the motion for review and also allows her to go. Yep. Well, apparently, Edward says, Becky, the court clerk, is allowed to do that. It's apparently one of those things not allowed, but never punished. No, it's going to the South Carolina Supreme Court, actually. That was a jury tampering issue that might have a whole bunch of legs, right? Just like the jury tampering issue in this case might have a whole bunch of legs. And Scott, kindergarten cop, do you remember last year for Christmas what I got you for Christmas? And I bought it for myself too, because I thought it was going to go off the market. I bought Becky Hill's book for myself and for my moderator's kindergarten cop, Scott, just thinking that it would be such a great collector's item because they said they were taking it off the market. And I went on Amazon real quick. He changed his name. Ding, 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 ding. So that we both have a copy of Becky Hill's book. Just in case, just in case. We'll see what happens. Murdaugh does deserve a new trial. I agree. And whether you think he's guilty or not, what Becky Hill, the court clerk, did with that jury, in my opinion, is grounds for a new trial. Emily calls her Becky Boo. I love that. I love it. It's fantastic. All right, 565. Moving right along, but let's first go to the chat. We got to hit these questions on that motion for the view. Could he bring in the canon regarding Argo? I don't know, Bella Brat, but I would not want to miss that day of testimony. Well, I'm not going to miss any of the days of testimony because we're all going to be here together. But I mean, could he bring in that canon? He made a canon and it was awesome. They were both awesome too. The Crash Daddies are amazing. Thank you, Bella Brat. Bias Bev is here and says, but I don't believe the feds will announce to their opposition anything. And can we have Ashley Merchant join the defense team? It doesn't seem like Judge Cannoni is going to allow any more attorneys to come in from out of state, but she has enough attorneys. Don't you have enough attorneys, Ms. Reed? Something funny, Ms. Reed? Don't you have enough attorneys, Ms. Reed? Yeah, the reason they got to go out of state to get attorneys, Your Honor, is because nobody who practices in Massachusetts wants to touch this hot potato of a case, including the 50 attorneys sitting in the Norfolk County DA's office. So they had to go out and hire a defense attorney in the name of, oh, wait a second. It's time for the name tag, Hank Breenan. Hello, my name is Hank Breenan, and I am to try this case for the tune of something like $225,000. And the 50 attorneys inside the Norfolk County DA's office won't try it. And there are many Massachusetts attorneys who are scared to even talk about this case. They're afraid. They don't want to speak out. They may have to appear in front of you someday. And then what will happen? Because all of the judges there are appointed for life. I think it's for life. Maybe they have a mandatory retirement age. I don't know. I could be wrong on that. So there's that. That's why we need pro hoc vice attorneys, Your Honor, because attorneys outside of Massachusetts are outraged that this is even allowed to continue or happen in the first place, or that the rules of evidence don't even seem to exist, and neither do chains of custody, evidence logs, proper police procedure, and we could go on and on and on and on and on. Motions to dismiss still outstanding? I don't know, Alex, because I have 700 things in my inbox right now. Jason says, could they request a view from inside the house? We covered that. Thank you. They didn't ask for that, but I don't know. Kelly, it's raining motions. Hallelujah. It's raining motions and lemonade. Thank you, Kelly. I'm going to walk by with a German Shepherd named Chloe on that day. No, they block off the street on top. Don't do it. Don't do it. They block off the street. Nobody's going to be allowed in. They're going to have to hire Fanning to come and head up the security team because, you know, the only thing he did, he's an honorable man. He's prestigious. We pulled up some information on him the other day that might belie that statement. However, you know, they're going to put Fanning in charge of security again outside the courthouse because, you know, they have nobody else to do that. They got to guard Fairview Road. They're going to have to lock it down. AK, thanks for tuning in from Norway. Can the new people do whatever they want on their private property when the jury view is? Can they have free camera signs in the yard if they want to? I mean, freedom of speech, right? That's fantastic. Al dente, the jury needs to see the scene at night. Oh, they should ask for a nighttime view. But you know that the judge doesn't like to work past 4. So that might not be possible. And also the jury is not supposed to drive by that location on their own. So, you know, were they to drive by there at night, they wouldn't be allowed to. Because every day when they come into the courtroom, they say, did you do any outside investigation? And they're not allowed to do that. But that is a great idea, a nighttime view. Alex, motion to dismiss, still undecided. I don't know. Like I said, I have 400 things in my inbox right now. As far as I know, it has not been decided yet. If anybody knows that it has been decided, you can just say, yes, it's been decided without any other spoilers in the chat, and that would be nice. Living on Love, just want to say thank you. My 12-year-old just yelled down the hall saying, quick, Mommy, Melanie's on. Oh, hi. Hello to your son or daughter who's 12, who is enjoying watching and learning about the law and all of the terrible tragedies that happen throughout the United States when people are wrongfully prosecuted. There's nothing worse than seeing a trial of an innocent person happen once, but to have to watch it twice. We're here fighting for justice. We're here fighting for people who don't have a voice. And so thank you for teaching your children well. I love that. Living on love. Thank you. Emily also calls her Courthouse Becky. That's great. A Leslie's Google search. Not. Is that a nod to Borat by any chance? That suit is gray. Not. I think that was Borat. Here we are. 565, 565. Is the defendant's motion in limine to prohibit testimony regarding funds paid to experts for purposes of voir dire. Okay, hold on. I just got to take notes. This is Karen Reed's team again, moving the court in limine to exclude testimony regarding expenses incurred by Ms. Reed for expert voir dire. Given that these expert expenses were incurred based solely on the request of the Commonwealth and the mandate of the court, their inclusion in testimony would not be probative of any fact of consequence and would only be unduly prejudicial towards the defendant. That's a great point. That is a great point. I don't know that I've ever seen a motion in limine like this before. What they're saying is, listen, usually it's permissible to ask experts on the stand, does anybody pay you for your testimony today? And how much did they pay you? And did they pay you to draft a report? Right. And how much did they pay you for that? And then, you know, it gets the jury thinking, oh, you know, this witness is expensive. You know, perhaps they're biased because of all the money that the defendant had to pay them. Perhaps they're just being paid to say whatever the defendant wants them to say. This argument is saying, listen, you're forcing us to bring these experts in here for voir dire because of Breenan's ridiculous assertions that, for example, Dr. Russell is not qualified to opine on the cause of John O'Keefe's right arm injuries being dog bites when she's got more experience than anyone in the country on that subject.
You're the one who forced her to come in here for 2 full days of voir dire. And so if she charged us or Karen, whatever she charged Karen, you should not be able to ask her about, because it wasn't us who made her come here. It was you. And that's a great argument. That is a great argument. However, just to get back on my rant a little bit, the fact that Dr. Russell, the matron saint of the Karen Reed trial, was a close call as far as being allowed to testify about the injuries to John O'Keefe's right arm being from a dog, with her 30 years of emergency medicine physician experience, and the thousands of autopsies that she's done, and the hundreds and hundreds of dog bites that she's treated between her ER patients and the prisoners that she also treated, because she also worked in a prison. She was also a police officer for a period of time in Massachusetts. The fact that the judge thought that Dr. Russell being allowed to testify as an expert was a close call and subjected her to 2 full days of nonsense, and then allows a guy like Crosby to just be allowed in without a hearing, after she ruled in the first trial that Rentschler could not testify about the cause of John O'Keefe's injuries because he wasn't a medical doctor. Crosby is. He's not a medical doctor. He's got some sort of degree in veterinary science that nobody's ever heard of. He did something with Harvard. We're not sure. He's been admitted to testify in other courts as an expert, but we don't know on what topic or subject. And he's just sort of like given like the green light, like, come on in, you can testify. It's insane. It is complete credulity straining. Absolutely. Absolutely. Okay, so let's just get the pen ready, because it also helps me know that I've already read that portion, and then it helps me lose my place. Helps me not lose my place as much. Factual background. In advance of both the first and second trial in this matter, the Commonwealth requested and the court ordered in-person voir dire for defense expert witnesses, including the crash daddies, Dr. Daniel Wolf, Dr. Andrew Rentschler, and Dr. Marie Russell. As a result, Ms. Reed has had to expend significant resources to pay for out-of-state experts to travel to Norfolk Superior Court for voir dire hearings, which spanned multiple days. To the extent that the Commonwealth seeks to cross-examine these experts regarding any fees they have been paid to testify in connection with this case, the Commonwealth should be precluded from eliciting testimony regarding any fees expended to have the experts testify at voir dire hearings, which were conducted at the Commonwealth's request. Yes. Oh, yes. Oh, yes. Oh, yes, they were. I have never seen, I've been doing this for over 30 years, and in civil litigation, we deal with a lot of experts. I would submit to you that we deal with experts much more frequently than criminal defense attorneys do, because every products liability case, medical malpractice case, complex litigation, mass casualty events require tons and tons and tons of experts. And I have never, no, I'm not going to say never, but it is rare that you see experts as qualified as not only Dr. Russell, but also Dr. Rentschler and Dr. Wolf. And just the fact that they're hired by the Department of Defense and the NHL should tell you a little something. And just because Dr. Russell may not have testified a million times does not make her not an expert in her field. But the fact that these 3 witnesses had to sit through ridiculous voir dire hearings, calling into question their credentials, is asinine. Argument. Expenses incurred by Ms. Reed as a result of expert voir dire are irrelevant. The fees and expenses related to expert voir dire are entirely irrelevant to expert credibility and do not make any fact or consequence more or less probable. Yeah. Just because we may have had to pay the crash daddies to come in for voir dire and then for testimony, and it was a lot of money. Well, it really wasn't, because the 24,000 and change for 2 experts to fly in twice and prep and is not a lot of money in the world of experts, in the world of litigation. But just because we had to pay them doesn't make physics disappear. Doesn't mean there's no such thing as physics. And physics doesn't lie. Discussion of the fact that an expert witness is compensated for their time is acceptable so that juries may assess expert credibility and bias. And so they go on down the road of making that argument. And let's just see if there's anything. However, testimony about fees and expenses incurred as a result of voir dire have no bearing on an expert's credibility at trial. This is particularly the case here, where in-person voir dire was conducted at the request of the Commonwealth and where a significant portion of voir dire expenses came from travel and lodging. Discussion of fees and expenses incurred by the defense for expert voir dire would not provide the jury with any additional clarity about expert motivations or biases. The in-person voir dire of experts was conducted at the Commonwealth's request. Moreover, the defense would have no way of clarifying this issue on redirect without eliciting the fact that there was a voir dire hearing, which is information that the jury should not be privy to and would not understand. Great argument. Voir dire fees and expenses are separate from potentially relevant fees and expenses accrued at trial and therefore should be excluded. And point 2 says discussion of expert voir dire expenses would be significantly more prejudicial than probative. So even if the testimony regarding these voir dire expenses is deemed relevant, it would be far more prejudicial than probative. There's their argument. And then they go on to explain again, where probative value is outweighed by the risk of unfair prejudice, it will confuse the issues and may mislead the jury. So if it's unfair, it should be excluded. Discussion of expenses and fees for expert witnesses incurred as a result of the lengthy voir dire hearings would be highly prejudicial while lacking probative value. At least one expert had to testify at 2 separate voir dire hearings. The jury may come away with negative assumptions and feelings towards Ms. Reed, right? And that impedes her right to a fair trial. They may make assumptions about her financial situation or believe that the costs and expenses are related specifically to expert trial testimony. The jury could feel that the experts are hired guns based on these inflated numbers, or come to judge Ms. Reed based on assumptions about her financial situation. Such emotional considerations may impermissibly cloud the judgment of the jury and could lead to decisions based on these emotions rather than the established propositions of the case. Good argument, and they've got a case for it. This prejudice would not be remedied by an explanation of the expert voir dire process. In fact, such explanation would only serve to further prejudice Ms. Reed and confuse the jury. When expert voir dire is conducted out of the presence of the jury, the separation may be viewed as a tool to prevent bias towards or against the expert. And then they go on and on that it would create an inaccurate and improper issue of Ms. Reed's financial situation, which would cause unfair prejudice and a serious risk that the jury make credibility determinations based on the fact that voir dire was conducted at all. Discussion on point 3 is discussion at trial of expert voir dire expenses would undermine the voir dire process and principles of fairness. So I think it's going to be a little bit repetitive, but They say allowing testimony at trial regarding expenses incurred as a result of the voir dire hearings would undermine both the purpose of expert fee disclosure and the integrity of the expert voir dire process. If voir dire expenses are shared at trial, it could incentivize parties to insist on in-person expert voir dire to drive up litigation costs for the other side, and then present that inflated number to the jury to create a misleading and prejudicial image of the other party. That's a great argument. This incentive would pervert the voir dire process, turning it into a potential trial weapon as opposed to a tool used to assess expert qualifications. Well, I can think of one tool in this case. Can you? Conclusion, allowing testimony about the costs incurred by Ms. Reed during the expert voir dire process would be irrelevant, far more prejudicial than probative, and would ultimately undermine the integrity of the voir dire process. XOXO, please don't allow it in. Just the voir dire part, not the other part, where we pay them for testimony and their time. Alan Jackson, Elizabeth Little, David Yannetti, Robert Alessi. Just one tool. No, actually, you know what? Margie, you're right. There's more than one. There's quite a few tools in the box, as it were, for voir dire. All right, moving on. That was 565. Back to the questions. Meatball Marcy, Brian Albert will be up in the trees when the jury does the hearing at 34 Fairview. Look up, everyone, look up. Thank you. Annie Beb's liver snowplow video from Frankentruck would be great. We'll see what else. These are all cold reads for me because I could not even read them as quickly as they were coming in. Thank you. Bias Bev, imagine being a broke Latino or a black woman. Well, or just anybody who's considered indigent. Listen, Penny McGee was a white woman who was indigent for purposes of trial, and Larry Tipton was her very, very highly skilled public defender. So I don't think we need to restrict that to race. But thank you for your super chat. Gail says, hoping that Bev has cleared her diary 9 a.m. till 4 p.m. for full weeks doesn't seem fair to dip in and out. You know, she's very busy, Gail. She's very busy. I don't know. I don't know what her schedule is, but there's that. All right, moving on to 566. Defendant Karen Reed's motion for attorney-conducted panel voir dire. 566. And this is going to have to do with the way that the attorneys are allowed to select the jury. When I say these, okay. All right. So this has to do with the actual jury selection process. Again, this is a defense motion. And the defense is asking, pursuant to the rules of the Superior Court, for attorney-conducted panel voir dire of the jury veneer. The veneer is just the pool of jurors. In order to determine whether such potential juror stands indifferent. Okay, so let's see what they're asking for here. Ms. Reed requests that the defense counsel be permitted to conduct the panel voir dire of the jury veneer on the following subjects: whether previous experiences with the jury system or criminal legal system, characteristics of the case, including the media attention, or personal characteristics or concerns of the prospective jurors would impair their ability to be impartial, whether prospective jurors are biased in favor of law enforcement or have law enforcement related knowledge, whether prospective jurors hold strong personal beliefs about operating a vehicle under the influence of alcohol, whether prospective jurors have been involved in or have close friends or family members who would have been involved in DV relationships, whether prospective jurors or anyone close to them have been involved in a motor vehicle crash, whether prospective jurors have been the victim of any violent crimes, and whether prospective jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials. Ms. Reed reserves the right to ask reasonable follow-up questions to each prospective juror pursuant to Rule 6.3C of the Rules of the Superior Court. Argument. I need a sip. Hold on. Okay. Argument. Pursuant to General Law 234A 67D and Superior Court Rule 63B, the Superior Court is required to permit the requested attorney-conducted voir dire. Part of the Sixth Amendment right to an impartial jury is an adequate voir dire to identify unqualified jurors. Prior to 2014, there was no right to attorney-conducted voir dire in Massachusetts, and whether to permit attorney-conducted voir dire in any given case was entirely within the discretion of trial court judges. I was wondering about this because some jurisdictions, like New York, allow the attorneys to pick the jury, often without the judge even being in the room. And some jurisdictions have the judge do it. The judge does it. And the attorneys can submit questions. And based on judicial discretion, it's determined whether or not they're allowed to ask those questions and what questions are going to appear on the questionnaire that they're given when they come in. However, in an effort to better protect the right to an impartial jury and ultimately a fair trial, the Massachusetts legislature amended the General Law 234 in 2014. Through that amendment, the legislature created a right to attorney-conducted voir dire. The current version of the statute, so amended, states that in addition to whatever jury voir dire of the jury venire is conducted by the court shall permit, upon the request of any party's attorney or a self-represented party, the party's attorney or self-represented party, to conduct an oral examination of the prospective jurors at the discretion of the court. The Massachusetts SJC has interpreted this most recent version of the statute as creating a right to attorney-conducted voir dire, and accordingly has expressly stated that trial judges must permit attorney-conducted voir dire upon request. I was not at the I was not at jury selection for the first trial, and I do not know anyone who was, but if anybody in the chat was at jury selection, which the cameras are off for, if you know whether the attorneys conducted the jury selection process or the judge did, you can ask. I mean, you can chime in if you were there for jury selection. Hold, please. These things are coming in like crazy. Okay. Elise says, I know that Judge Bev denied the defense panel voir dire last time. Okay. Let's see. Turk, it was not televised. I had to cancel that stream because I couldn't find that it was going to be televised anywhere, and they were not even going to turn the Zoom on for that hearing. So yeah, it was at 2:00. I don't know how long it was, but we're going to cover that on delay. So we're going to cover it because the jury selection is supposed to start on the 25th, and I think it's supposed to be finished before Karen Reed trial starts. So there's that. Okay. Let's not get too in the weeds on this right now. Accordingly, because this request for attorney-conducted voir dire was properly and timely made, the court is required to permit attorney-conducted voir dire. Both sides chose the jury last time. Yes, for the first trial, Yannetti asked for a panel voir dire of the jury at the motions in limine and was denied. It's getting really warm in here, and I think it's time to turn the air conditioning on. Can you believe it? Can you believe it? Panel voir dire, for those of you who are asking what panel voir dire is, it is a jury selection process where attorneys can question prospective jurors as a group rather than individually to determine their suitability for jury service. But again, it says here in Massachusetts, it's also known as attorney-conducted voir dire, allowing attorneys to question jurors in front of the entire panel, the entire group, so they can ask questions of the entire panel or individual jurors within the panel. The trial judge may permit counsel to question jurors as a group, but the judge retains discretion to limit the scope and time of the questioning. Attorneys must ensure an accurate record of their questioning, and failure to refer to juror numbers may constitute a waiver of any claim or of error arising from inaudible or unattributed portions of the record. Yeah. So remember in the Ashley Benefield trial, the post-trial motions. Oh, no, I'm not boasting or complaining about the weather. I'm getting hot, so I'm going to need to take a break to get out there and turn the air conditioning on because it's too warm in here and I might pass out. Ashley Benefield, they called the jurors back because the question was, did one of the jurors lie on her jury questionnaire about being not only a perpetrator of DV, but also a victim of DV? And they had to go through the transcripts of the jury selection where the attorneys had asked the entire group of people, anyone who has ever been a victim of DV, please raise your paddle. And they had numbers on their paddles. And the court reporter would write down the numbers of all the people. And so they had to go through these transcripts to find out whether this juror lied or not and whether she raised her panel. And it was a whole thing. So this is very important to make an accurate record. All right. Talk amongst yourselves for a second. I'm going to have to go turn on the fan or the air. I will be right back. Take a quick break for a quick drink for yourself, because I don't want you to get dehydrated. And then we've already been here for 2 hours and 15 minutes and we need to take a little powder. Be right back. Okay. Now I'm back. Okay. Where was I? Speaking of fans and air conditioning, this is a little tongue in cheek, but not really. Hang on. I'm of the opinion that more divorces occur due to temperature regulation than money. Because some people like air conditioning and some people don't. Some people like to sleep in a cold room and some people like to keep the heat up really, really high. And I think that more divorces occur over the air conditioning fight than than money. So there's that. I can't live without air conditioning. I'm an air conditioning girl. And I like to sleep in like maybe I'm an Eskimo because I love to sleep in like a really super cold room. Right? So there's that. Like as soon as it gets warm enough. Yeah, individual thermostats, but like even in the car. Remember before cars had the individual thermostats on either side? And you had to like deal with the air conditioning or not having the air conditioning on when you were a kid. Yes. Okay. That's just my 2 cents. Point 2. We're back to the jury selection motion. All questions proposed by defense counsel are consistent with the guidance in Superior Court Rule 6 and necessary to ensure Ms. Reed's Sixth Amendment right, and so should be allowed. While trial court judges must grant attorney-conducted voir dire when properly and timely requested, the judge retains discretion over the scope of attorney-conducted voir dire. Saying they can impose reasonable limitations. Let's just kind of skip through this because I think we have some stuff with some more meat on it coming up. But I will slowly scroll through in case you don't have access to these documents and you want to read them later. You know, a lot of times judges just want to take control of jury selection because they don't want it to drag on forever. They don't want it to take too long. They're on a tight schedule. They want the trial to start quickly. And so sometimes if attorneys are left to their own devices, they'll take a long time. And they go through the rules. And Rule 6. Which includes permitting parties and their attorneys to participate in the process of identifying potential juror biases. And really, that's what you're looking for. You're looking for fair jurors. You're looking for people who can be fair. You're looking for people who, even if they've heard about the case, are able to keep an open mind and don't have their mind already made up. Because I don't think they're ever going to find 12 people in Norfolk County who have not heard about this case. But the question is, can you be fair? Can you be fair? Can you come in, listen to all the evidence, wait until the close of evidence to formulate your opinions? Right? Because there's not going to be, you're not going to find 12 people who haven't heard about Karen Reed in Norfolk County. No way. No way. And do you really want to anyway? Because those are the people who have kind of like, are they not paying attention to what's going on in their own community? I mean, that would be kind of shocking to me. April 1st is the day that jury selection is supposed to start. So it's not that the trial is supposed to start on the 1st. That's the jury selection start date, supposedly. The subjects that defense counsel has proposed for attorney-conducted voir dire are subjects into which Rule 6 instructs inquiry should be allowed. Most of the proposed voir dire subjects will aid defense counsel in evaluating prospector's juror's ability to be impartial by eliciting specific evidence of relevant biases, such as, well, let's look at footnote 3 here, which says specifically, this font is killing me here. Specifically, defense counsel seeks to inquire of the jury whether previous experiences with the jury system or criminal legal system, characteristics of the case, including the media attention, or personal characteristics or concerns of the prospective jurors would impair their ability to be impartial, whether prospective jurors are biased in favor of law enforcement or have a law enforcement related knowledge, whether prospective jurors hold strong beliefs about operating a vehicle under the influence of alcohol, whether prospective jurors have been involved in or have close friends or family members who have been involved in domestic violence relationships, whether prospective jurors or anyone close to them have been involved in a motor vehicle crash, and whether prospective jurors have been the victims of any violent crimes. And look, all of these questions can be helpful to both sides, because remember when I had Vinnie Politan on as a guest recently, and Vinnie told us that when he was a kid, his neighbors that he was good friends with, I think, the entire family died in a drunk driving accident. And so people come into these cases with their own personal experiences. And if, such as Vinnie, and he said, like, this is where I'm coming from. Like, I'm really against drunk driving. And she admitted to drinking, and this is why. And he does think that there's not enough evidence to convict her, that there's tons of reasonable doubt. But he said that for him personally, he's got a problem with drinking and driving. And there are so many people who have been affected by drunk driving, and they will not be able to put that aside. And they will think to themselves, listen, if all these people were drinking and driving and somebody died, somebody's got to be held responsible. And she's the only one here. So we're going to hold her responsible. Right? I don't think she had nine drinks, but I know that in one of the interviews that I saw, she admitted to having 4. So, there's going to be people, let's not diss Vinnie. This was not an invitation to disparage Vinnie Politan. But yes, you can't avoid your own personal bias, right? And if they all drove drunk again, but they're not all on trial. I know people love to bring that up, Scooter, and I'm not calling you out or like even just like throwing any shade to you. And people say, yeah, but everybody's drinking and driving. Right. That's an even bigger problem, because people who have had family members killed by drunk drivers, for them, the whole thing is going to be a problem, right? If you have jurors who know about this case and they know of the vitriol involved with this case because they happen to go on Twitter every day and read about it and see that the people that are involved about talking about this case simply and reading court documents are being personally doxxed, threatened, disparaged. The things that they're saying about Mark Betterow on Twitter right now, forget it. Things they were saying about, Dr. Russell. I mean, and it goes both ways. But a juror might just be like, listen, I go on Twitter all the time. I see what's happening over there, and I do not want any part of this. And they should be able to weed those people out, right? If they have cops in their family and they're like, well, cops don't lie. Cops don't lie. I can't be impartial. I mean, if a cop comes up here and is testifying, I'm going to believe everything he has to say. Or a juror could say, a prospective juror could say, oh, well, listen, all cops lie. All cops lie. You put a cop on us and I'm not going to believe a goddamn thing that they say. I've lived here my whole life, and trust me when I tell you the cops are the police are corrupt or whatever. You got to weed those people out, right? So this what's good for the goose is good for the gander. And so these are important questions that need to be asked in order to flesh out any jurors who may have personal biases. And look, you can say that you're gonna leave your biases at the door. You're not going to let it affect you, but inherently we all have them, right? We all have them. And so the defense is pointing out these are all things that we need to be able to weed out, and we need to ask questions about, because all of these things are pertinent in the case, and that they may reveal preconceptions or biases relating to the identity of the parties, or the natures of the claims or issues expected to arise in the case. With respect to proposed questions on the subject of the bias due to media attention, in particular, Massachusetts courts have recognized the potential biasing effect of extensive pretrial media coverage of a case. Where pretrial publicity renders the risk of juror bias particularly acute or especially significant, both this court and the U.S. Supreme Court have emphasized the need for an adequate voir dire. Ms. Reed's case has been highly publicized, both in Massachusetts and nationally, and I would submit to you internationally. How many international viewers do we have here? If you are international, tell us where you're watching from. I love to see. We have a huge audience in Ireland, Scotland, Denmark, Sweden, South Africa, Australia, New Zealand, UK. Yeah, here's UK right here. You guys are here. I see you. I see you, Australia. I see Germany, Finland, Canada, Brazil, Hungary, Nova Scotia, Ireland. You guys are all here. My Scots, my Irish, Romania in the chat, Sweden. The world is watching. Scotland, Texas. Well, that's right. You're not from Texas. I put that on the playlist for you. Well, I love it. You're not from Texas. And also, she's already made up her mind. Another great Lyle Lovett tune. Czech Republic is here. South Boston is here, which might as well be out of this world. You guys are awesome. Holland is here. Since this criminal case began, newspapers and news networks, including the Boston Globe, Boston 25 News, the New York Times, Vox, NBC, CBS, and the Washington Post, to name a few, have been covering Ms. Reed's criminal case, some publishing about the case repeatedly over the course of months. Yeah, and many of them have incorrect information. For example, the initial reporting that came out, I think it was WBZ, you can correct me if I'm wrong, said in the initial reports that came out on January 29th of 2022, investigators say that they have ring camera footage of the incident. News at 11. And it's still out there. And guess who picked that up, Toot Sweet? The Daily Mail. It was across the pond within seconds, and it's still out there. And guess what happened? Oh, that video doesn't exist. The ring camera footage of Karen hitting John with her car doesn't exist, but they put it out there right away, and it's still out there. You can find it. Given the significant media coverage of this case and the resulting likelihood that many potential jurors will have learned information about the case through the news, it will be particularly difficult to impanel an unbiased jury for Ms. Reed's second trial. As such, allowing defense counsel to question jurors on the subject of media attention the case has garnered is necessary to ensure the impartiality that Ms. Reed is constitutionally entitled to. Questions on the remaining proposed subject of whether prospective jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials should be allowed as inquiries into the prospective jurors' willingness and ability to accept and apply pertinent legal principles as instructed. And here in the footnotes are a whole bunch of articles. Rule 6.3c thus affirmatively counsels that each of defense counsel's proposed voir dire subjects should be allowed. And also, here's point B, she has a constitutional right to an impartial jury, and so therefore we need to ask the panel about these questions. And here's some U.S. Supreme Court cases that say so. And then they say, without an adequate voir dire, the trial judge's responsibility to remove prospective jurors who will not be able to impartially follow the court's instructions and evaluate the evidence cannot be fulfilled. Given that the defense counsel's proposed questions contravene no part of Rule 6, fall within the type of question which Rule 6 counsels should be allowed in reasonable number and are necessary to ensure adequate voir dire, and thus Ms. Reed's constitutional right to an impartial jury, this court should permit defense counsel to inquire into all the subjects included in its proposed questionnaire. And these are questions about drunk driving, law enforcement in your family, whether you have any bias towards for or against law enforcement, for, drunk driving, domestic violence. And we went over all of those things before. XOXO, please allow this. Thank you. Love the defense. All right. So that's 566 questions. I mean, is she just going to take like a big rubber stamp and be like, denied, denied, denied? Up now is docket number 567, docket number 567. Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witness once they have taken the stand. Okay, this is going to be a good one. This is going to be a good one because we talked about this a lot. We talked about how there were day breaks. There were day breaks during the testimony of percipient witnesses like Proctor, like Buchanan. They testified one day, then there was a day off for a weekend, and then they came back. Was the Commonwealth speaking to these witnesses while they were still technically under oath? They're not allowed to. They're not supposed to. Were they? I don't know, but we're going to need to read the motion to find that out. Bev's Rubber Stamp is here with some advice. Says, have a hot cup of tea with honey to protect your throat. I have special throat spray. It is a vocal throat spray. Thank you so very much, but it's too hot to right now drink hot tea. But I appreciate you for looking out for me. Thank you. Bobby Alessi's linguistic prowess. It's too much of a tongue twister, that name. I'm just going to call you BALP, okay? I just put my jammies on because I feel like we're pulling an all-nighter here. Yeah, well, we're here for as long as it takes because the world is watching and everyone needs to know about this stuff. Thank you. Thank you. Thank you for watching. I appreciate you. Mighty Ducks. The Commonwealth is preying on our credulity by trying to sell us that Auntie Bev isn't biased against Karen Reed and that John O'Keefe was hit by a car. Thank you for loving my commentary, Mighty Ducks, for your super chat. On top says the AC is life. 70 degrees year round. Oh, I like 68. If I'm in a hotel, I'll take it down to like 65. No joke. Amy's Positive Pathways says, my husband makes me freeze, but no divorce. Have heated blanket and heated car seats. Opposites attract. That's good. That's good that you figured out a way to work it out. And that's why you're Amy's Positive Pathways, because you found a path of positivity to make it through. And that's fantastic. Deja Vu Trial 2 says, Melanie is my go-to for anything Karen Reed. I would pay for Melanie to review everything with Emily. I don't. Okay, well, we're not here to disparage her either, but thank you for paying $10. RB became a member and Jenny became a member. And Edinburgh is here with Katie Fisher in the house from Scotland. Thank you so much for loving it. And I love you even more. Okay, here we go. What number did I say this was? This is number 567, 567, 567, and 789. This is a kindergarten class. See how much you learn here? And this time, we are now moving in this latest motion in Lemonade. The defense is moving this court to issue an order prohibiting the Commonwealth and its agents, including but not limited to the prosecution, law enforcement, and victim witness advocates, from speaking with or having any contact with any witness once the witness has taken the stand. Oh, here. They're going to point out to us what they learned. Hold on. I got to spray my throat. For anybody who's interested in this, if you are a creator, this is great. It's called Clear Voice Vocal Spray. Prevents vocal fry. Also, entertainers. There's another one called Entertainers something, but it just took too long for Amazon to get here. So hold on. Because here's the bombshell. During Miss Reed's first trial, the defense learned that the Commonwealth was having improper conversations with witnesses while they were in the middle of their testimony. That is sanctionable. That is an ethical violation. But you see how, the defense isn't real petty like that. They're not out there making motions for sanctions and for spanky hanky. To spank Hank. For example, on cross-examination, Brian Albert indicated that he had spoken with attorney Assistant District Attorney ADA Adam Lally over the lunch hour while the court was in recess during the middle of his testimony. I think, didn't we I think we pointed that out during the first trial. When asked what they had discussed, he initially denied speaking about the substance of his testimony, but then he later admitted that ADA Lally had discussed some of the topics he wanted to ask him on redirect. Quote, he maybe mentioned one thing he may ask me, just he was going to ask me about what happened at the house in the morning. You know, some of the questions on redirect, that's all. That's all. That's a big problem. I did point it out, right? I think I would have went nuts over that. I think my head would have popped off. Right, Olivia? Was some of it outside our presence? I don't know, but I think my head would have popped off. Pretty sure it would. Right. Bubsy says not just international subscribers, we have international creators following the Karen Reed case. Yeah, Broken Baker is one of them. He's a good dude. He's the muffin. I'm the cupcake. As grounds for this motion, Ms. Reed states that the court has discretion to prohibit communication between witnesses and attorneys or third parties. Well, also, isn't that like just obvious that they're not allowed to do that? Do we really need to spell it out? They know they're not allowed to do it, but apparently everything needs to be spelled out here because even things that we think are so obvious that shouldn't have to be pointed out, like, you know, preserving the evidence of the murder weapon and producing it with metadata shouldn't have to be a court order telling you to do that, because as a prosecutor, you have an affirmative obligation and duty to preserve and maintain all evidence related to the crime or the alleged crime. There doesn't need to be a court order demanding that you do it. So here we are in the upside down, inside out world of the Hunger Games and Matrix, Narnia. Here's the argument. In order to preserve the truth-seeking function of the trial, the court should prohibit agents of the Commonwealth from communicating with any witness once the witness has taken the stand. This is a particular concern during a recess or lunch break in which there is virtual certainty that any conversation between the witnesses and the lawyer would relate to the ongoing testimony. For similar reasons, the Massachusetts Rules of Criminal Procedure permits a judge to exclude a witness other than the criminal defendant from the courtroom when they are not testifying. The sequestration of witnesses serves an important function in preventing one's witness testimony from being inadvertently molded by the testimony of other witnesses. Right. And they're not supposed to be watching it on YouTube either, or Law and Crime, or Court TV. The same danger that a witness's testimony may be molded by conversations with others is present when the witness speaks with the prosecution or other agents of the Commonwealth during breaks in their testimony. And we know that all of the law enforcement involved in this case are extensions of the prosecution. They work for the prosecution. They are one and the same. All the proctors, Buchanans, all the state troopers, the Canton PD, the victim witness advocate, they are all extensions of the prosecution. And so they are not allowed to speak to the witnesses either when they are under oath and in the middle of their testimony, not just during breaks, on lunch breaks, but on weekends or on day breaks in between. Because if Brian Albert admitted to that on the stand, because quite frankly, he lied about everything else, in my opinion, of course, what happened with the other witnesses that perhaps may have met with anybody from the DA's office or victims witness advocates or law enforcement on the days off and the days between. Days between. There's a Grateful Dead song. We don't know. Let's see if they point anything out. The same danger that a witness's testimony may be molded by conversations with others is present when the witness speaks with the prosecution or other agents of the Commonwealth during breaks in their testimony. Conclusion: for the above reasons, Ms. Reed respectfully requests that this court issue an order prohibiting the Commonwealth and its agents, including but not limited to, because we need to spell it out, the prosecution, law enforcement, and victim witness advocates from speaking with or having any contact with any witness once the witness has taken the stand. And that was docket number 567. And that should be granted, like just automatically rubber stamped, but you never know. XOXO, the stellar defense team. Bear with me a second while I pull up our next documents. Let's see, 567. We now need 568. Do we have 568? Let's see, 568. Hold, please. Okay. Moving now to 568 and 569. Defendant's motion to impound, defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. So this is just basically a motion to impound. Another motion, good cause exists because it makes reference to grand jury proceedings. Okay, so that is the motion to impound that. And then 569 is Elizabeth Little's affidavit saying why, just saying that good cause exists to impound that motion. So that's 568 and 569. And then it looks like 570 is that motion, so that is likely impounded. And I wonder if there's a redacted copy. Give me a second. 565. Where am I? 570. I think they're already up to 599. So we got a long way to go. Everyone, go settle in, get a drink. So I imagine 570 is exhausted, is impounded, but we've got 571, which is going to be one of my favorite motions. And I knew they would make this one again, and I'm here for it. Okay. All right, back to what did I say? 570. Hang on. Move this here. Move that there. All right. 570 is impounded. That is the motion to that is the motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses because it includes grand jury testimony. And so therefore, I believe it is impounded because I don't have it. But we are moving on anyway to docket number 571, docket number 571. This is one of my favorite motions, and I'm so glad they made this again. This is defendant's motion in limine to exclude Serum Plaza. Back to one. Defendant's motion in limine to exclude serum plasma ethanol concentration, blood ethanol, blood ethanol concentration, conversion, and corresponding retrograde extrapolation analysis. This is one of the most important testimonies in this trial. And I said, and we've talked about this recently, that I knew they would make this motion again because now they have the benefit of the testimony of the hospitalists or the people who worked in the lab at the hospital. Karen's blood was taken in the hospital after she was sectioned. I think it was only a CBC that was done. It was not the official test that the MSP would take a blood test for to determine whether or not you can be charged with OUI. We call it DUI or DWI here in New York. And that person who testified said, this is junk, basically. We don't know when she had her last drink. The blood that we draw is not supposed to be used in court, not supposed to be used in court. There were also different ways of taking the blood, things that it had to be done a certain way. It wasn't done a certain way. And so now that we have the benefit of hearing all of that testimony, I said the defense should make that motion again. I said, right. I said the same thing. The blood alcohol level should never have been allowed. Even their own witness from the Commonwealth was like, yeah, no, this isn't accurate. It's not reliable. And they had like a crazy swing. The swing was something like they extrapolated it back to say that at 12:30 or, in the beginning of the case, it was 12:45. She hit him with her car and then it morphed to like 12:30 by closings. That, we didn't really know when she had her last drink, but they extrapolated to say something like her blood alcohol content would have been somewhere between, and you can tell me what the numbers were, 1.3 or 0.13 and 0.26. Like there was such a crazy swing that it was like, how could this ever even be admissible? Right, Mudrucker, that's what he said. And what if the time of her last drink was wrong, was the question the witness was asked. And he said that all my super careful math goes out the window real hard. Yes. He was even embarrassed to be there, I think, because he was like, this is not exactly what, we're supposed to be here using this for. And Olivia says the MSP recently completely rewrote its protocol and procedures for taking blood alcohol content because of a huge scandal with them using faulty breathalyzers, giving false readouts. Are you shocked? Are you shocked? I mean, if they've got video altering programs on their laptop, do you really think they've got a problem with using faulty breathalyzers? I don't know. It's a rhetorical question. Now comes the defendant and respectfully moves this court to exclude evidence of a serum/plasma ethanol concentration test performed by Good Sam Hospital at 9:08 a.m. on January 29th of 2022. The fact that this was allowed in to begin with, I screamed a lot about before the first trial because my opinion has always been, what if she went home and drank a bottle of vodka? And that's the whole reason that she was getting ramped up in her voicemail messages to John. And she was getting angrier and angrier and angrier because maybe she went back to One Meadows and started drinking. Isn't that possible? Well, we don't know that unless Karen takes the stand. And guess what? You can't force her to take the stand because, there's constitutional provisions against that. She cannot be forced, compelled to testify. And so how could any blood draw that was done at 9:08 a.m. be even used? Because it wasn't done at the scene. It wasn't even done properly. And the extrapolation is junk. It's junk, in my opinion. By extension, Ms. Reed necessarily moves to exclude the blood ethanol concentration conversion performed by the Massachusetts State Police, as well as the corresponding retrograde extrapolation analysis. As grounds for this motion, Ms. Reed states that is acknowledged by MSP forensic scientist Nicholas Roberts. Yes, remember Nicholas Roberts? No relation to Carrie Roberts and her husband, I forget his name, But I remember this witness because I really liked him a lot. He was totally like credible, believable. And he's like, yeah, what am I doing here? Like, I don't even want to be here. In his reports, the ethanol result used in the reports was provided by an external party. The testing to obtain the ethanol result was not performed at the MSP crime lab, and therefore the reports do not fall under the laboratory's scope of accreditation. See Exhibit A and Exhibit B. Kurt Roberts, that's Carrie's husband. Remember, he said that Carrie would be in a mood when she got home if he didn't shovel the driveway, and he also had a curfew, and that was the reason that, wasn't that the reason that Karen had to come to CF McCarthy's because John needed a ride because Kurt had a curfew and he had to be home? Because Carrie would be in a mood. Since the Commonwealth cannot establish that the blood test result administered by Good Sam Medical Center is reliable for the purposes of a criminal prosecution, the serum/plasma ethanol concentration result and the corresponding blood ethanol conversion and retrograde extrapolation, which derive the results from the initial result, should be excluded as unreliable and not the product of reliable principle and methods. You know, methodology is really a thing. It's really a thing. You know, in the rest of the world. Factual background. Okay, so we're going to get into why they took our blood and under what circumstances and how. On January 29, 2022, at around 7:26 a.m., Ms. Reed was admitted to Good Samaritan Medical Center as a result of the acute grief reaction she experienced after learning that her then boyfriend, Officer John O'Keefe, had passed away. In addition to evaluating her, the hospital performed blood work and a urine drug test, which included tests for the presence of drugs and alcohol. Ms. Reed tested negative for any drugs for which the hospital screened. The hospital, however, recorded an alcohol level in Ms. Reed's blood of 93 milligrams per deciliter. Using the value from the test conducted by the hospital and without ever having applied for a warrant to themselves test Ms. Reed's blood, as would be the normal course in a prosecution involving any aggravated form of operating under the influence, Massachusetts State Police performed a conversion of the reported 93 milligrams per deciliter result to a blood ethanol concentration ranging from, oh, here it is, 0.07 gram, is that a G? Gram percent to 0.083 gram percent. I thought it was a way bigger swing than that. Based on 3 different conversion factors on May 4th of 2022. Using that conversion, Mr. Roberts then conducted, a retrograde extrapolation. Okay, so they're saying that when she came into the hospital, they converted these blood results to 0.078 to 0.083. Using that conversion, Mr. Roberts then conducted a retrograde extrapolation, meaning he's going to take it back to the time of the accident, but he didn't do that until June 6th of 2022. In both reports, Mr. Roberts explicitly notes that the serum/plasma ethanol concentration obtained from Good Sam Medical Center was not performed at the MSP crime lab, and therefore this report does not fall under the laboratory's scope of accreditation. After the first trial on September 17th of 2024, the Toxicology Unit Administrative Manual updated conversion factors used by the MSP crime lab to align with ANSI/ASB best practice recommendation 122. Per a new report dated October 10th of 2024, authored by forensic scientist Hannah Knowles, the new serum plasma ethanol concentration estimated by the Massachusetts State Police Crime Lab is now between 0.078% and 0.082%. See Exhibit C, report by Hannah Knowles. Do you think Hannah Knowles is going to be one of the new expert witnesses? I vote yes. I vote yes. Otherwise, how would they have her report? Moreover, in Null's report, she uses a time interval of 8.5 hours with an additional 2-hour allowance from the time of 12:45 a.m., the time of the alleged incident, in an attempt to account for the uncertainties associated with the drinking history of the subject prior to the time interval. Her calculation determined that Ms. Reed's BAC could have been, oh no, then this is not their witness, because she's saying Karen's blood alcohol could have been between 0.14 and 0.28. Okay. Little bit of a swing between 0.14 and 0.28 at 00:45 hours on 1/29/22. And that is footnote 1. This range differs from the range testified to by the forensic scientist used by the Commonwealth at the first trial, Nicholas Roberts, who indicated the range would have been between 0.13 and 0.29. Okay, so maybe it is one of their witnesses. It appears Hannah Knowles is a reporter. Oh, okay. Okay. Olivia says, I read Hannah Knowles' memo or report regarding the MSP BAC protocols, and KCL says she's a reporter. I don't know. We'll see. This calculation assumes that the subject's BAC had peaked at or prior to the start of the time interval, indicating that the subject had consumed no ethanol 0.5, a half an hour to an hour and a half hours prior to the time interval. Argument. Because both the initial serum plasma conversion report and the subsequent retrograde extrapolation analysis are based on a blood test about which the parties lack essential information, including testing procedures and type of testing, the blood test results should be excluded. Yeah, she would be dead. She was 0.28. She's tiny. Retrograde extrapolation is a mathematical calculation used to estimate a person's blood alcohol level at a particular point in time by working backward from the time the blood alcohol test was taken, taking into consideration rates of both absorption and excretion. The SJC has held that, generally speaking, retrograde extrapolation analysis meets the Daubert-Lanigan standard for admissibility. Breathalyzer test results are generally admissible without the need for retrograde extrapolation, without the need for expert testimony when taken within a reasonable time, defined by the SJC as 3 hours after operation of a vehicle. Calori lays out, and that's a case, a narrow exception in which expert testimony is required, where the Commonwealth is proceeding under an imperitability theory as opposed to a per se theory, and a test is administered outside of the 3-hour window, necessitating retrograde extrapolation. Expert testimony is required. Okay, so if the blood was drawn more than 3 hours from the event, you must call a witness, according to the case law in Massachusetts. Just last year, the SJC addressed the issue of a defendant's consent to a blood test in a prosecution for simple and aggravated forms of OUI in companion cases, Commonwealth versus Capalucci and Commonwealth versus Zucchino. Oh, the Italians out there making case law. I love it. Both 2024 cases. The court held that the consent requirement of MGL 90-24-1E only applies in prosecutions for simple OUI under General Law 90, rather than to any of the aggravated forms of OUI. Accordingly, whether Ms. Reed consented to the alcohol blood test or not is not at issue here. What is at issue, however, is that the parties lack essential information about how Good Sam Medical Center drew and tested Ms. Reed's blood. It is standard practice in prosecutions for OUI and its aggravated forms for police to request and be granted a warrant so they can themselves test a defendant's blood through a certified analyst. While these requirements pertain only to analysts working for the state police and not to hospital personnel, they are in place to ensure that blood testing for ethanol undergoes a standardized, reliable, repeatable procedure. Footnote 2. No. Bob's a law nerd. There is no crash report for this. There's no police accident report for this. There's no crash report at all. No motor vehicle accident report. Even though they decided within 16 hours that it was a car accident that killed Officer John O'Keefe, and Karen Reed did it, they never saw fit to fill out a crash report. Footnote 2 says the admissibility, according to 50 MAPP RAC, the admissibility of any given test result will be governed by the adherence to the policies and procedures, and while strict adherence may not be required, any variance will certainly affect the weight given the evidence by the fact finder regulations for the analysis of blood contained in 501 CMR 218-220. Okay. So the reason that consent is not required according to these two cases from 2024, because I imagine that if these two cases didn't come up, they may have been able to argue that she didn't give consent, but because they're saying here that the consent requirement is only required for if you're just charged with drunk driving. If there's an aggravating factor like a death resulting from drunk driving, then consent is not at issue. That is why it is not at issue here, because according to the Commonwealth theory, Karen Reed was drunk when she hit and killed John O'Keefe intentionally. But they're saying what is at issue is how the blood was drawn and tested. It is standard practice in prosecutions for OUI and its aggravated forms for police to request and be granted a warrant so that they can themselves test a defendant's blood through a certified analyst in accordance with the provisions that we just read. And we just read that whole part. So moving on. The Massachusetts State Police utilize gas chromatography testing rather than enzymatic immunoassay testing, which presumably was used by the hospital here. So if we go to footnote 3, that has to do with the chromatography testing. There's a citation for that. And then there's also a citation for footnote 4, which is enzymatic immunoassay testing. In the medical records provided under the chemistry section, there is an annotation regarding the drug testing, which states, this report is intended for use in clinical monitoring and management of patients. It is not intended for use in employment-related drug testing or court-related proceedings. And remember, that witness was was cross-examined about that extensively. He was like, yeah, no, these results are not supposed to be used in court. Samples are not routinely tested for adulteration and are assumed to be within the normal physiological pH range of 5 to 8 inches. 5 to 8 inches? Or 5 to 8? I don't know. Oh, that's a quote, I think. See attached page of Good Samaritan medical records. The alcohol result is beneath this annotation. It is not clear whether this annotation applies only to the urine drug screen or to the alcohol result as well. Regardless, the defense should not have to guess. The Commonwealth should have, at a minimum, provided documentation from the hospital regarding how the alcohol test result was obtained, through what procedure, by whom, and what manner or testing was used, i.e. gas chromatography or enzymatic testing, the latter of which would yield a higher result. They should not have to guess. Absent this information, the Commonwealth is unable to establish the reliability of this initial result on its face. In light of the fact that the MSP, Mr. Roberts and Ms. Knowles, each separately acknowledged in their respective reports that the serum plasma ethanol concentration test does not meet the accreditation standards for reliability outlined in this statute, we know with certainty that the serum plasma ethanol concentration test was at the very least conducted according to an entirely different scientific protocol. So there's that. The defense does not take issue with the generally accepted scientific practice of retrograde extrapolation itself, but rather with the data upon which it was based. Without reliable foundational information about the initial serum plasma result, the serum plasma conversion to blood ethanol concentration and the retrograde extrapolation from the converted number is not reliable. More precisely, the Commonwealth has not provided any information about the initial result from the hospital that would indicate that the subsequent analyses by Mr. Roberts and or Ms. Knowles are accurate. Instead, 3 parties involved in this BAC test have expressly disclaimed the legal veracity of these results, and they did. They all testified, and they all said, these are not supposed to be used in court. General Law 90 states that a certificate signed and sworn to by a chemist of the Department of the State Police or by a chemist of a laboratory certified by the Department of Public Health, which contains the results of an analysis made by such chemist of the percentage of alcohol in such blood, shall be prima facie evidence of the percentage of alcohol in such blood. The analysis of Ms. Reed's blood was not in fact made, at least not completely, by the chemist who signed and swore their certificate, as is admitted to in the reports by the MSP, Mr. Roberts and or Ms. Knowles. In his testimony at trial, Mr. Roberts admitted that while the standard lab testing procedure is to conduct 2 separate tests within the laboratory, with Ms. Reed's sample to be conducted with Ms. Reed's sample, he conducted no testing himself and merely assumed that the hospital's test was accurate. Yeah. Both of their analyses were conducted with data that they did not themselves collect. Mr. Roberts himself confirmed that an unreliable base for calculation like we have here is a serious problem for the reliability of the extrapolation result. And he said in his testimony, you do have to base the extrapolation on good. Your starting blocks have to be good. So you have to know the times in which the blood was drawn, the time of the incident, and essentially what your value was for your BAC. All 3 of Mr. Roberts' key factors are not clearly known. Moreover, the prior retrograde extrapolation was not in keeping with ANSI ASB best practices, and thus the new forensic scientist Hannah Knowles has now issued a report with a new and different range of BAC, further underscoring the unreliability of the extrapolation in this case. Okay, so maybe this is going to be a Commonwealth witness? Hannah Knowles? Does anybody know? Addressing the issue of pure evidentiary admissibility, GL 23379 tells us that records kept by hospitals shall be admissible and may be admitted by the court in its discretion as evidence in the courts of the Commonwealth so far as such records relate to the treatment and medical history of such cases. And then they go on and say that in this case, it was expanded to say that medical records generated for evaluation and treatment purposes do not constitute testimonial evidence and may be admitted into evidence. Both the statute on point and seminal case on medical record admissibility pose conjunctive requirements, treatment and medical history, and evaluation and treatment. The common factor between the 2 authorities is treatment. Ms. Reed's visit to Good Samaritan Medical Center on January 29, 2022, and the records produced therefrom were explicitly not part of any process of the administration of medical treatment. Oh, so then they shouldn't even be admissible at all under Massachusetts' own case law. Commonwealth v. Malone decided the same year as Dyer found that when the defendant's blood test was not connected to medical treatment, Commonwealth's failure to meet the statutory requirements means that the documented hospital records themselves cannot be admitted under the hearsay exception. Therefore, Ms. Reed's serum/plasma Ethanol concentration results should be excluded. Conclusion, throw it out, don't let it in. For the above reasons, Ms. Reed respectfully requests that the blood test result from Good Samaritan Medical Center, the serum plasma conversion, and retrograde extrapolation evidence be excluded. Excluded. All right, so that was docket number, what is that? 571. I'm going to need a bigger pad. Talk amongst yourselves for a second. Uncivil law is starting a class action. He says, have you been harmed by the stupid? You may be entitled to compensation. Contact the uncivil law firm today. Woot woot. All of this is stupid. LA, thank you for putting all of the countries' flags that are in chat into your emojis. I appreciate you for your super chat. My name is Hank Breenan. My name is Jeff. Noel says, probably a stupid question, but can the defense object to videos being submitted if no chain of custody, forcing the Commonwealth to put everyone who handled the video on the stand before they could be introduced? Well, we're looking for an evidentiary hearing on all that stuff. And it's not a stupid question, but we still have like 20 more papers to go through, and maybe it's in there. Let's see. Thank you, Noel. I appreciate your super chat so much. Truth be told, why doesn't the prosecution have to pay for voir dire? Well, because they're the defense's witnesses. If she had a public defender, the state would be paying for them to come in, but she doesn't qualify for one, so she's got to pay for them. Hang on. And that's why. Thank you, truth be told. Uncivil, thank you for super chat. Motion and lemonade to stop the government from stupid. Oh yeah, and that's where your class action is based. I got it. I missed that because I'm behind. Unless he's a Google search not. I don't think the voicemail should be entered either. You should hear my voice with my husband of 27 years. Well, I think that's coming in. I think it's coming in. Kyle, using their extrapolation, Karen Reed be dead at 1 a.m. Thank you for your super chat. Josh says, absent consent, wouldn't a warrant be required? No, they don't need it when there's an aggravating circumstance like a death. And that's what the case law in Massachusetts says. And apparently those two cases were just decided in 2024. So if I'm reading those wrong, let me know. But it's a great question. Thanks, Josh. And I'm behind, so you may have asked that before we went over that. Nina says, am I wrong, or did Hank argue that the second-degree murder charge is because Karen intentionally drove a car while being drunk? Not that her intention was to murder. Well, I think there was, no, I think that was the manslaughter charge that you're thinking of. And so that's hurting my brain right now, but the murder charge requires intent. If anybody in the chat can, like, adjust that for me, but I'm pretty sure the murder charge requires intent and the manslaughter charge would not. Although there are so many cases that I'm conflating at this that no, it was the murder charge. Well, you know what, Nina, I'm going to have to go back and look because I don't want to give you a wrong answer. But in the meantime, I'm going to thank you for your super chat. So thank you. Do we think anybody's going to roll? I don't know. Grandma lives in the basement is here, and she became a member. So thank you, Grandma. I'm sad that you live in the basement, but that's awesome. So that was 571. 571 was BAC. 572. Is a motion to impound defendant's motion and eliminate to exclude witnesses' prior criminal history. All right, so I think this one is probably going to be impounded too, so we'll be able to skip forward. Hold on. So they want to impound a motion that they made to exclude Karen Reed's, or to exclude witnesses' prior criminal history. I don't know which witness we're talking about, because it doesn't say defendant's prior criminal history, so it's a witness. They want to impound that motion. Good cause exists for this motion. So that's 5-7. It's been a long time since I've done that. I swiped. You know, it's so funny because I just saw Melanie Little's left swipe in StreamYard go by. And I'm like, wow, that's so funny. I haven't done that in such a long time. And then I did. I was trying to get this motion over here. And StreamYard's got a lot of nerve. They sell their company, they double their prices, and their service stinks even more than it did before. Whatevs. Don't sweat the small stuff. So it's some witnesses' prior criminal history that they want to impound that motion about because it refers to arrest records. So that's 572. Hang on. Let me see if I can skip through a couple of these because you guys say the Commonwealth ones are really good, but no spoilers, please, because, you know, we're behind. And then 573 is Elizabeth Little swearing to that stuff. And now this can come down. That brings us to and that's as far as I got. Now I got to download a whole bunch more. So talk amongst yourselves for a second. Talk amongst yourselves for a second. Oi, oi. So I think 570 is impounded. And then we just did what? 572, 573. These are all going to be out of order. So we're going to have to you're going to have to give me a sec. Okay, so the Commonwealth starts there. Okay, got it. Got it. All right, where are the rest of those motions that I just pulled up? Everybody go get a drink or something because this is going to take me a minute. I could sing for you, but I don't think you want that. I don't think you want any part of that. Okay. Where did they just go? Oh, for the love of the traveling Mary. What number is that? 582. Where were we? 572, 3. $575. Need 576. $570. $9. Okay. All right. The next one that I think is in order here, we left off at 573. Now, we go to 575. All right, so I'm going to assume that 574 is impounded, and that was the motion regarding whatever witness that is, and their criminal history. And then we get to 575, which starts the Commonwealth's motions. Okay, all right, everybody with me? You with me? You still with me? Did we lose anybody? Amora Valesi, would you kindly remind us of all of Bev's seats and responsibilities alongside the bench in Norfolk County? Seats and responsibilities. I don't know what that means. Seats and responsibilities. I mean, she was the administrative judge in Norfolk County. She's not anymore. I originally read that to mean North Carolina. Her duties and responsibilities. I don't. She was the administrative judge in Norfolk County. And so I don't know if that's what you're referring to. I don't think she is anymore, right? So I don't know if that's what you're referring to. She has been specially assigned to this case for trial. But in order to answer that question, I'm going to need no typos and some more information. But I appreciate your super chat. Thank you. Bobby Leslie is married, everyone, just in case you were wondering. So you know. I feel like we are in law school and watching a master class. Love this so much. READ. Should I change my name to ML's Pajama Party? Serving motions in lemonade? Yeah, sure. You can do whatever you want. I'll allow it. Hannah Knowles, forensic scientist, 3 state of Massachusetts. So she's employed by the state, and she's a forensic scientist 3. Marianne, is that what you're telling me? My deciphering is getting better. Thank you. I guess that's her title, forensic scientist 3 for the state of Massachusetts. Thanks, Marianne. Melanie Little's left swipe in StreamYard is giving me a super chat to apologize. It's not your fault. Thank you. Chris Albert's death by DUI. Yeah, Chris Albert did kill a man in a drunk driving accident many years ago. And for those of you who don't know, his attorney was Judge Cannoni's brother. Yeah, his name's Prescott. Chris Albert killed, I think, an exchange student, right? If I remember correctly, and he didn't turn himself in for something like 30 hours. And by then it was way too far. Way too much time had passed to do blood alcohol testing. And he got 6 months. Somebody said he got 6 months. Yeah. Hit and run. Yep. It was a hit and run. Yep. And his attorney was Judge Cannoni's brother. His name's Prescott. I forget which Prescott it is, but that is right, Dennis. You are correct. And Olivia said, well, we don't know for sure if it was per se drunk driving because it was a hit and run because he fled and right. So we don't know if it was drunk driving. Right. So to be fair, his name is Peter Berger. Say his name. Thank you, Olivia, for pointing that out. Say his name. His name was Peter Berger. He was killed by Chris Albert many years ago. I don't know how old Chris Albert was at the time. Do you guys know how old he was at the time? And I believe he was incarcerated for 6 months. He did turn himself in eventually after 30 or so hours. And John Courtney says the obvious, we need squirt bottles with holy water. Yeah, so it wasn't drunk driving. Okay, but it was in 1994. But I do believe it was 1994. I do believe that Paul O'Keefe had been arrested for drunk driving and that Karen Reed bailed him out, right? And that would have happened during the 2 years that Karen and John were together. So there's that. Rest in peace, Peter Berger. Old enough to know better. Yeah. Aunt Bev's Newports. Auntie Bev's Newports are here. Oh my God. Is there anything worse than menthol cigarettes? Because everyone, you know, at least I'm Gen X. We all smoked at one point. But I didn't like menthol cigarettes. And also Parliament with that hollow filter, gross, says you learn more about actual court watching Melanie than you do in law school. Trust me. Thank you. Thank you so much. Forrest Dump is here and says Peter Berger, say his name, was 22. Chris Albert was 30-ish. Little Cupcake says he left the scene and then he called in all the friendly favors. Yeah, he called the friendlies. Yeah, so there's that. For those of you who didn't know that, there's that. Let's get to some Commonwealth motions, shall we? It's been a good 3.5 hours here. Really? We all smoked? I thought we did, didn't we? Didn't we, Denise? I don't know. Maybe you didn't. But I mean, back in the day, I mean, it was like before, like when my mother was pregnant with me, it's like they didn't even know smoking was bad. I think everyone smoked when they were pregnant. That was, in the 60s. So it was different. It was different back then. It was a different time. All right, the friendlies. Max, you know about the friendlies, don't you? Amanda loves spending her days here. I love having you here. And Water Off Alessi's back became a YouTube member. Thank you. Thank you. Jackie Young became a YouTube member. Thank you. All right. Let's keep moving. We're like, I think I can. It's like the little engine that could. We're going to do it. We're going to do it. We're going to get through it. We've got a lot more to go. So many of you may have to go and come back and watch it on the replay. But tis what it is. We ain't got no quit. This is the Commonwealth's motion in limine to appoint court stenographer, prevent identification of jurors, and impound juror names during trial. Well, pretty sure they probably made that motion last time, and it's like another one that's kind of like, all right, well, obviously, duh, but we're going to do it. So this is starting docket number 575. This is Commonwealth. Okay, so they want to appoint a court reporter for the trial, impounded the names of all jurors, and that sidebar discussions and juror names be unavailable to the public until a verdict is returned. Well, they're still not available to the public from the first trial, and that is because this case is still going on. Commonwealth also requests that spectators and journalists be ordered to refrain from attempting to provide specific identifying information of juror, if you're in South Carolina, they say jurors down in the Low Country, or potential jurors to the public. Okay. Norfolk Superior Court uses traditional courtroom stenographers and for the record equipment. That's what it's called, for the record, FTR equipment, right? And that's when they talk into the athletic supporter. Tell me that does not. Tell me, Madam Court supporter. Tell me, Madam Court supporter is not talking into an athletic supporter, because that's what it looked like to me. Anybody who's ever had a son who played sports knows what I'm talking about. Or if you played sports yourself. So it's for the record. That's what it's called, FTR. FTR recordings may be available less than 24 hours after the courtroom event without any opportunity for a party to have notice or an opportunity to object or for a judge to consider a request for access to sidebar discussion. It appears that anyone can create an FTR account and a request for access to a particular recording, which will be reviewed by a clerk who authorizes access until there is an order of impoundment or other judicial proceeding, other judicial process prohibiting access. Oh, it appears. Is this the first time you figured this out? Did you not know this before? Oh, here we go. I got to put the name tag back up. It appears that anyone can create an FTR. How long have they been using the FTR system? And why is it just appearing? You know why it's just appearing? Because there's a new player in town, and his name is Hank Breenan, and apparently he doesn't even know anything about FTR recordings. But anybody can create an account and pay for a transcript, and a lowly clerk, will authorize access. You know what's so funny about that? Is that there was a woman who worked in Stoughton District Court who was fired for giving some sort of court documents to Aidan Carney or something like that, right? You can correct my information. She was fired. Respect the clerk. I love the clerks. You got to bring the clerks arugula, and then they give you whatever you want sometimes. Well, here in New York anyway. But this is what he's saying. That if you don't order this, judge, some clerk is just going to give access to anybody who wants to pay for the transcript. And we can't have that, Your Honor. We can't have that because, we don't believe in transparency. The absence of an order of impoundment of all sidebar discussions could result in those discussions being publicly disseminated during trial and potentially prejudicing the parties. You talking to me? You talking to me, Breenan? Showing of good cause may overcome the public's right of access to judicial records. Yeah, Hey, Judge Gull, hold my White Claw. How'd you do it? How'd you do it, Gull? How'd you get away with it? Got any tips and pointers for me? In determining whether good cause has been shown, a judge must balance the rights of the parties based on the facts of the case. Oh, here we go. The SJC has stated that good cause is readily apparent in circumstances including 1, the impoundment of the names and addresses of seated jurors during the course of a highly visible trial, where the risk of inappropriate juror contact would jeopardize a party's right to a fair trial. Oh, you mean the person who followed one of the jurors allegedly to a bar and then recorded their conversations and then maybe gave them to someone who might know, Trooper Fanning, who wasn't in charge of the jury, but may have been in charge of all of the shenanigans going on outside the courtroom in the outside parking lot. He was in charge of security and then maybe telling a court officer about it and maybe just maybe telling the judge and then having that juror dismissed without a hearing. Remember, you mean like that? Oh, cool. Got it. 2, the impoundment of the response of jurors who highly invasive or personal questions posed during individual voir dire. Okay. Oh, are they worried that people are going to get the voir dire transcripts? Okay. The defendant, law enforcement officers, and potential witnesses have been the subject of intense media interest and scrutiny. At least he put the defendant in there too. Members of the public have engaged in notable activities in conjunction with the prosecution of this case, including private citizens protesting at the courthouse. I would say that they're supporting, but sound bites, and private citizens engaging in relentless harassment and acts to intimidate witnesses from testifying at trial. Here we go. Oh, are you referring to all of the twidiots who posted Dr. Wolf's family online and his wife's Facebook page and the relentless harassment of Dr. Wolf? When I say Dr. Wolf, I mean Crash Daddy Wolf, not the other neurologist Wolf. Or the relentless harassment that the twidiots have subjected Richard Green to, the expert for the defense, and pulling up some old bar fight records and maybe an old mugshot and trying to get him not to testify? Do you mean like that? Or is it just when it suits your purposes? Because, people are being mean to the people that Michael Morrisey intended to defend during his hostage statement. The consequences of these efforts has reached past jurors and a grand jury member. Huh. Security is also a significant concern. The publication of security concerns or measures discussed at sidebar would undermine the ability of the court to maintain order and could jeopardize the proceedings. Well, I don't think any of the jurors' names should be made public. I'm completely on board with that. I think that everyone would agree with you. The publication of matters discussed at sidebar relative to jurors while trials ongoing, including juror names, information, and potentially sensitive responses to inquiry, could prejudice the parties and expose jurors to extraneous matters. Yeah, I agree. But not every sidebar involves a juror. Most of them are arguing objections because the court will not allow objections to be heard in open court like a regular courtroom in a real state. Sorry, I said it, and I'm not sorry. The Commonwealth anticipates that after a verdict is returned, the potential prejudice to the parties will be greatly lessened and that all parts of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. Well, I'm going to submit to you that depending on what the verdict is, it could be even more dangerous for the jurors' names to be out there. So, there's that. But, FTR, free the record. So they want FTR impoundment. I guess that's what this motion is. What is this called? Prevent okay, well, I'm cool with all of that stuff, but they want every single sidebar impounded. I don't know. My brain hurts, and I from what you're telling me in the chat, in the pre-chat chat, is that my brain's going to hurt even worse once I start moving on through the rest of these Commonwealth motions. So might as well keep going. 576, docket number 576, and this is Commonwealth's motion in limine for sequestration order and for relief from that order for family members of the victim. All right, so 576, Commonwealth sequestration. Commonwealth moves for an order of sequestration of all witnesses expected to testify at trial. Oh, this is where they're going to try and keep Karen's parents out. They're going to put Karen's parents on the witness list and her brother so that they got to stay out. Oh, okay. Wait a second. I don't know. This is a cold read. Don't tell me. But if he's doing this, it's sleazy. Let's go. The Commonwealth further requests that this court allow the following potential witnesses to be accepted from the sequestration order. Hold on. I got to get the red pen. The red pen is coming out. So he wants these people to allow to be there. Okay. The victim's brother, Paul O'Keefe. The victim's sister-in-law, Erin O'Keefe. Oh, Spanky. Do you not know? Do you not know about Erin O'Keefe? I don't think she's coming back. The victim's niece and nephew. The victim's mother, Peggy O'Keefe. The defendant's father, William Reed. Oh, that's very nice. They're gonna let him stay. The defendant's mother, Janet Reed. That's nice of you. And the defendant's brother, Nathan Reed. Okay, so you're gonna allow that they all stay, but anybody else who's on the list should have to stay out. Okay. I mean, I don't know. Let's see. So far, I'm not really mad about it. Argument. Decisions concerning the sequestration of witnesses are ones within the judge's discretion. The court has the discretion to allow the family and friends of the victim to observe the trial after the Commonwealth's case in chief has been completed. Additionally, the family members of a deceased victim have the right to be present at all court proceedings unless the court determines that their testimony would be materially affected by hearing other testimony. Which witnesses will be called in the Commonwealth's case in chief or rebuttal cannot be reasonably decided pre-trial. Really? You don't know who you're going to call yet? You're not going to call every single person? Oh, Kelly isn't a witness. That's right. That's right. So she should be allowed in there. John's father. Oh, yeah, I think John's father was on the list. Yeah. Oh, no. No, he's not on the list. That's interesting. The victim's mother, Peggy O'Keefe. You're right. Where's John's father? John O'Keefe. Thank you, Kathleen, for being eagle-eyed. Is he tapping out? Is he like, I'm out? I'm not coming back? Maybe you could swap out him for Aaron because Aaron's definitely not coming back, in my opinion. That doesn't. Yeah, he's not on the list. Notably absent. Huh. All right. Judge has discretion on whether or not to sequestrate them or sequester them. Sequestrate is not a word. Sequester. Hold on a second. I need a drink. Why would Aaron not come back? Okay, Lauren, and this is for everyone in the chat. I don't really want to talk about it. I'm only going to say that if you want to know what happened potentially between Paul O'Keefe and another woman, maybe, who he was messaging on Facebook through the first trial, you can go to turtleboynews.com and he's got the full story there, including screenshots of all the text messages and Facebook messages and things like that. And if I were Aaron, I would be already filed for divorce, but that's just me, including the mirror selfie, which was not something I can unsee. So Lauren, check it out. You won't be able to unsee it either. And for anyone else in the chat who has no idea what I'm talking about, let's not get sidetracked, but I'm just going to tell you that. All right. The court has discretion to allow those people in. And they're saying the Commonwealth's case in chief cannot be reasonably decided pre-trial. He sent them out in a bulk mailing. I saw someone put in the chat. That was very funny. The subpoenas have been sent out using bulk mail. It will depend upon the introduction of evidence and cross-examination. Testimony of many of the witnesses will be brief, but may not necessarily occur at the beginning of the Commonwealth's case. Other witnesses, including the defendant's family members, are tentative and may not be decided until near the end of the trial. Yeah, okay. Well, you know what? There's no way in hell that you're calling Mr. and Mrs. Reed to the stand. Don't even pretend that you are, because they will sink your case. Oh, it wasn't last trial. It was last month. Oh, Sunny Drop. Thank you. It's last month. Yeah, it's burned in my mind forever, says Wayne. And TD says that feeling of betrayal is awful to have. I know. I feel bad for her. I do. Other witnesses, including the family members, tentative, may not be decided until near the end of trial, excluding the defendant's family members who eventually may not be called would be an unfair infringement upon the defendant's supports network. Wow. Imagine that. Spanky's got heart. If the Commonwealth reserves the defense family members for rebuttal, and the defendant should choose to testify, the Commonwealth would seek exclusion of the defendant's family members during her testimony. Okay. Well, that'll be a game time decision. So there's good cause to relieve those above witnesses from the sequestration and impose the limitations suggested. And then it says, footnote 1, the Commonwealth is not seeking for the witnesses to be relieved from the portions of the sequestration order that bars them from discussing their testimony with witnesses who have not yet testified. Yeah, that's true. That should be enforced. Yeah, 100%. 100%. You're not allowed to go telling people about testimony or discussing your testimony with other people because the other people who have yet to testify are not supposed to. Yeah, Kelly Reed is her relative, but she's not going to be called as a witness, so that's not an issue. Right? This is only concerning potential witnesses. Kelly's, in no world would Kelly be called as a witness. She didn't witness anything. XOXO. Hank Breenan. All right, what was this? This was 576. Moving on. Okay, that was, what was that? That was 575. Now we are at 577. 577. Commonwealth's motion in limine to allow in-court identification. This is going to be, they're going to want people to be able to point at Karen Reed, I think. Commonwealth moves in limine to allow an in-court identification of the defendant in accordance with the rule announced on December 17th of 2014. Oops. And here they said, where an eyewitness did not participate before trial in an identification procedure, good reason for an in-court identification must be shown. Let's see what the reasoning is for this. As in the case law, there was no out-of-court identification procedure conducted prior to the trial. The Commonwealth intends to lay a foundation. Oh, there's a new concept, laying a foundation? What is that? What is that? Can you believe it? My head might pop off. The Commonwealth intends to lay a foundation. Well, there's something new. That the witnesses were familiar with the defendant prior to January 29th, 2022, the date the defendant is alleged to have murdered John O'Keefe. The Commonwealth's witnesses include individuals who are friendly with the defendant and knew her through her relationship with the victim. This is not a case where a particular witness is identifying the defendant based solely upon his or her memory of witnessing the defendant around the time of the crime. All right, so here we want people to be able to say, do you know Karen Reed? Yes. Can you see her in the courtroom? Yes, that's her. That's her. Okay. I mean, I don't really have too much of a problem with that one. So I guess whatever's coming up is going to make me mad, right? All right, let's see. 577. Why does it skip to 579? Well, we got 579 here, so let's take a look at that. Oh, here's where they don't want to talk. They don't want to talk about the death certificate. We saw this in the first trial too. So 579, Commonwealth's motion in limine to preclude reference to and redact the manner of death contained on the victim's death certificate. For those of you who do not know, The manner of death listed on the death certificate, according to Irene Scordi-Bello, the medical examiner, is undetermined. It does not say homicide, despite the best efforts of Michael Proctor and Yuri Buchanan to get her to change that manner of death from undetermined to homicide. She wouldn't do it. She wouldn't do it. So the Commonwealth does not want that to be able to be brought up, and it was granted last time. And so here they say, in accord with settled practice, the death certificate be redacted for the means and manner of death. Footnote 1 says, in this case, the means and manner of death on the death certificate is undetermined. Well, she granted it last time. And they don't want any mention that it's undetermined. They say, according to General Law 46, nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. In a criminal trial, excluding from the death certificate the words homicide, suicide, accident, or in this case, undetermined, is the better and safer course. Where the defendant does not dispute the validity of the death certificate or the fact that John O'Keefe is dead, the question of liability is left solely to the trial jury. For the above reasons, the Commonwealth asks that this court preclude any reference to and redact the manner of death contained in the victim's death certificate. And she did grant that last time. Hang on one second. Hold, please. All righty. Your head is spinning. My head is spinning. No, your head is spinning. The Commonwealth is a weird place. It is such a weird place. It's not how we do it in Massachusetts is here. Oh, hi, Jody. Jody's here. She's a Gen X and she's never smoked a darn thing. Good for you, girl. All right. Say goodbye to 579. And let's go to the chat for a couple of questions. Nina said, Hank said they have to prove second-degree murder and that Karen Reed's intention was to drive drunk. That's how Officer John O'Keefe ended up dead. Hank said that when? Hank hasn't been the trial attorney yet. So again, he said that in open court, like during a motion. He says a lot of stuff when he gets up in open court that are lies and misstatements of the truth and what he needs to prove. And I don't think he really understands the standards of evidence, but so that she intended to drive drunk and not kill him. And that's second-degree murder. One day we'll go and we'll look at the statute again. I just don't have time for it today, but thank you, Nina. I appreciate you. Piney Woods, again, I think the defense should file a second motion to recuse just to put the recent Bev shenanigans on the record for appeal. It's so important. Thanks again. Love this chat. I think they should too. And I maybe we'll see it. Thanks again. Gail, do they not do random drug and alcohol tests in places of work in Massachusetts, particularly employees in charge of vehicles? I do not know. Gail, I can't opine on that. I don't know. I don't live there. Maybe somebody in the chat knows. Thanks, Gail. I thought she was on some ethics or oversight of jurist board. I know that she was involved in the committee to rewrite Rule 14. I do know that, but I don't know if she's on an ethics or an oversight of jurist board. If anybody in the chat knows, can you tag Amora Valesi and let her know? Thank you. I'm not privy to that information, but that would be interesting. On top, a Hungarian in his 20s, sadly, that was Peter Berger, right? Smoke him if you got him. Thanks for 2 super chats. Hank's magic fact wand is here from Canada and says, thanks for a great day at the lemonade stand. Oh, you're very, very welcome. Hi, Barbara. Thanks for your 50. I'm just hopping on. Thanks for covering. I go back and see what I missed Had a neck procedure this morning. Oh my goodness. I hope you're okay. Maybe it was just an adjustment from a chiropractor or some trigger point injections. I don't imagine that you would be texting, that you would be super chatting if you had spinal surgery this morning. So plenty of rest and watching time, but flew to Vegas for a week first. This summer, Red Rocks. Amazing. Amazing. Love Vegas. Thanks, Barbara. Nina, we need to hold my White Claw emoji. Oh, I'll think about that because we have the Dr. Pepper from Sarah Boone. Maybe we can turn that into a White Claw. Well done, Nina. Well done. Thank you, Nina, again for all the super chats today. Glenda, classy lady. Thanks, Melanie. Thank you, Glenda. Piney Woods became a member. Thank you, Piney Woods. Oops. Lola the good dog. Hank left unchecked becomes a gaslighting, whiny, corrupt, endless Sally Port video. Shit show of a trial for Karen Reed. Thank you for your super chat. Everybody, don't forget to smash the like button. Helps the algorithm. And also hit subscribe. It's free. I need one of those silver play buttons to get to, if I get to 100,000, YouTube gives me one of those silver play buttons. Random thoughts. I'm still trying to catch up. I loved and looked upon my teacher as my heroes. Take it as a compliment. I would send my kids to you to be educated. Oh, that's sweet. Thank you, Random Thoughts. Brian Miller. I thought John's dad thought Karen was innocent. I don't know. I have no personal knowledge of that. There was a rumor of that. I know that they did used to go to church together. But I do not know. I do not know what he thinks or doesn't think. I have no personal insight into that, but thanks for your super chat, Brian. Karen says, joining late. Been going a long time. Yeah, there's about 25 motions that we're trying to get through. It is FUBAR, 100%. Thank you, Karen, for your super chat. And on top for being so sweet and putting another super sticker in there. Thank you so much. All right, we're going to keep going. We're the little engine that could here. We're going to keep moving. Everybody's going to hit the like button. I don't want to have to turn off the fan. Except it is getting chilly in here now, so I might. Melanie, I don't think she granted it last time. Maybe she just excluded the death certificate. I thought it was redacted, Olivia, but I could be wrong. I could be wrong. I thought it was, did they not get to see it at all? Yeah. I don't know. Right. We're not done. There's more. Oh yeah, we're only on 582. There's like 599. So settle in. You want to take a short break? Everyone go get a little something to drink, a little popcorn. And take a little drink. That'll give me time to 582 to download the rest of these. So let's do that. Let's take 5 minutes. All right, everybody, 5 minutes. Everybody go get your snacks. It's snack time. Go get your snacks from the Cubbies, everyone. Snacks are being allowed. We're now having snack time. We're going to take five, take a powder, go use the ladies, whatever you need to do. And we're going to be right back. I'm going to put this up. It says court is on a break, but it just means that we are on a break. So take 5. Be right back. Okay, we're back. Did everyone get their snacks? Took me a while to download all that stuff and look through it to see what really pissed me off the most, to see what we're going to cover next. And I have a great candidate for you. So hang on one second. Okay, are you ready? Take a breath, because this is going to make you mad too. But here we go. Docket number 589. Docket number 589. This is the Commonwealth's motion to prevent the defendant from raising a third-party culprit defense. Ding, 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 ding. Just when you thought it was all about the defendant having a fair trial in Norfolk County, it's about the Commonwealth having a fair trial in Norfolk County, my friends. Maybe the first part of this craziness was boring for you, but here's Alice above my head, because we have fallen into the Mad Hatter's Tea Party, the rabbit hole of rabbit holes. And in 6 pages, the Commonwealth is going to explain to you and the world why they don't think the defendant, Karen Reed, should be allowed to use a third-party culprit defense. They're pulling a Delphi. They're pulling a Delphi. This requires a red pen. Docket number 589. Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. Hank is Nick McLeland for real, somebody said. I may need more colors for this one. Yeah, we may. Ready? Breathe in. Breathe out. Somebody's pointing out, yep, they succeeded in Delphi. Hey, Gull. Hold my white claw. Now comes the Commonwealth and respectfully requests this court preclude the defendant from raising a third-party culprit defense. The defense position has chronically been fluid and unsubstantiated. Really? Chronically? The defense claim has been nebulous from its origin. Nebulous, chronically unsubstantiated. Okay. Quote, Karen, just to be clear, you didn't do it? End quote. We know who did it, Steve. We know. And we know who spearheaded this cover up. You all know. Footnote 1. Many of you know where that came from. Anybody remember where that came from? I believe that was on the courthouse steps, but let's check footnote 1 and see if I'm right. Oh, it's just a YouTube link, but I think that was on the first, that was on the courthouse steps. After the first trial, the defense position began transformation. Quote, we're going to retool everything, and maybe some things will stay some more, but we were going to shuffle a lot of things around. Okay, that's got to be misquoted, but I'm going to read it again exactly how it is written. We're going to retool everything, and maybe some things will stay some more, but we're going to shuffle a lot of things around. I can bet you anything that's not what she said. We're going to shuffle. That's probably supposed to mean we're, but you know what? We shouldn't have to try and figure it out. This is not a puzzle. This is not a game. This is not a dress rehearsal. This is real ducking life. And if you can't even quote someone properly when you've got video of it and subtitles to help you in case you can't understand what she's saying, but she doesn't mumble. Karen Reed, the defendant. Here's a link of the YouTube clip from which they pulled that, which apparently the judge should have to click on and go watch to try and figure out what they're saying here. And maybe some things will stay, some more. She didn't say that. But, this is not a wordle. Most recently, in its Fox 25 sit down, the defense responded to the question, in your opinion, there have been a few names that have surfaced in this third-party culpability theory. Who do you think, if John was beaten up and attacked in that house, who did it? Defense counsel uttered, we don't know. The defendant quickly uttered, we don't know. Counsel furthered, quote, and it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John. But who was it specifically? Others know, and they're not talking. Okay, well, there's no citation for that. So where's the YouTube link so the judge can look it up to fact check you? Or so that the defense can fact check you? Because you don't give, there's no footnote for that. The evolving responses have vacillated from an unidentified certain villain to not knowing who is responsible and have been the hallmark of the defense's third-party culprit claims since its inception. I guess he got the thesaurus out. Or maybe AI, ChatGPT. The defense is not entitled to simply engage in scorched earth tactics, making baseless and incendiary claims about witnesses without any evidentiary foundation. Well, here's the thing, Mr. Breenan. The jury is the fact finder here. It's the jury. Who's the fact finder? And the defense is entitled to put on a defense. You want to talk about changing theories? In the first trial, I know you weren't here, and you probably haven't watched it, but in the first trial, in his opening, Lally said that Karen Reed murdered John at 12:45. He did. Then, in closing, Lally said Karen Reed murdered John at 12:30. Yeah, he did. Right, exactly, Zoe. Thank you. Great mind. Zoe says, let's talk about the Commonwealth's theory changing during the first trial when they realized their entire theory didn't add up when Karen Reed's cell phone connected to Wi-Fi way too early for their theory. And you know what else I bet they're going to change? I bet Trooper Paul's entire theory about the pirouette and the, being thrown 30 feet into the lawn, and bet that whole theory is going to change too. So, there's that. And Olivia says, notice how all Brennan ever cites to are quotes made outside of court. So we know Hank watched all of Karen and her attorney's out-of-court interviews, but he still has not finished the trial. Yes. Yes. Prior to the first trial, the court made rulings relative to the defense's third-party culprit claims. The court ordered, based on the offer of proof on Friday, I am well within my rights, pursuant to the case law, to exclude the third-party culprit defense. Oh, we remember that day. I'm not going to do that now. I'm going to give you a chance to develop it through relevant, competent, admissible evidence, but you cannot open on it. So that is my ruling on that. And he cites to footnote 3, which is a YouTube link. I don't know. How about in your paragraph, you put the date that the judge said that? I don't know. Just a thought. Despite the court's clear ruling, the defense launched into its third-party claims from the beginning of its opening statement. Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death, and that means that somebody else did. Well, you know what? That's going to go down as maybe one of the best openings of all time. Just saying. You watched it. Right, Zoe. The Commonwealth three-point turn changed to driving in reverse 60 feet. Yes. Oh, sweetie, no. I'm tired of people saying Brennan is some kind of dynamo. He sucks. Just like Marietta Sullivan said Karen Reed sucks. She sucks. Followed by, because the Alberts were involved and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit. The evidence identifying or establishing a third-party culprit was never forthcoming throughout the trial, and to this day continues to be non-existent. It's for a jury. It's for a jury to decide. But it stands to reason that if Karen Reed didn't do it and if John O'Keefe was not hit by a car, somebody else did. Because I don't think that your doctors are going to say that he could have just slipped and smashed his head onto that hard as rock ground and shattered his skull in a whole bunch of different places. And then how did those wounds to his arm occur? Wild coyotes? The Massachusetts Guide to Evidence, 1105, section 1105, provides that evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that the evidence has substantial probative value. In making this determination, the court must make a preliminary finding that the evidence is relevant, is not too remote or speculative, and will not tend to prejudice or confuse the jury. If the evidence is otherwise inadmissible, the court must also find that there are substantial connecting links between the crime charged and a third party, or between the crime charged and another crime that could not have been committed by the defendant. Emphasis added. After 3 years, the defendant has yet to provide any evidence as to whom they suggest is the third party culprit responsible for the victim's death. Well, here's the thing. They don't have to prove it. They don't have to prove it. You do. The burden of proof is on you. There is a nexus. After 3 years, the defendant has yet to prove any evidence as to whom they suggest is a third-party culprit responsible for the victim's death, or any evidence of alternative circumstances that would have caused the victim's death. John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. And you can't prove it beyond a reasonable doubt. The absence of an evidentiary basis to support a third-party culprit defense was clear before the start of the first trial. No, you weren't there. To accept the defendant's third-party culprit defense, the court would have to find the defendant demonstrated that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as the person who committed the crime. Again, John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. That's where she left him. That's where he ended up dead. Right. Karen's supposed to play detective now. Right. Apparently, as is the jury. Like, the jury is confused about their role, too. It's like they're sitting back there thinking they got to figure out who did it. No, what they got to figure out is whether or not there's reasonable doubt that Karen Reed did do it. Or that John O'Keefe was hit by a car. Great point. The evidence must have a rational tendency to prove the issue raised and cannot be too remote or speculative. Therefore, the defendant would have to provide evidence of substantial probative value that another individual had the motive, intent, and opportunity to commit not only murder, but vehicular manslaughter and leaving the scene after causing death. No, she doesn't need to provide evidence that somebody else committed vehicular manslaughter and leaving the scene after causing death. Am I in the Twilight Zone? I mean, I know that I am, but I'm just looking for validation. The defendant would have to provide evidence that another individual did not only commit murder, but also vehicular manslaughter and leaving the scene after causing. There was no car accident. There's not even a car accident report. Goes to the weight, not the admissibility, Mr. Breenan. Thank you, Emily. I don't think he understands. He doesn't understand. And he cites a case, Commonwealth versus Andrade, introduction of third-party culprit evidence subject to ordinary considerations of relevance. Let's put a big arrow there for later. To raise a third-party culprit defense to one charge that is closely intertwined with the other charges would pose a real threat of prejudice by confusing jurors and diverting their attention to wholly collateral matters involving persons not on trial. Well, maybe they should be. Citing some cases. The defendant's right to present a third-party culprit defense is not absolute, and the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. Yeah, we wouldn't want to prejudice the Commonwealth because it inevitably diverts jurors' attention away from the defendant on trial and onto the third party, and essentially requires the Commonwealth to prove beyond a reasonable doubt that the third party culprit did not commit the crime. Citing some cases. Additionally, hearsay offered for the truth of the matter asserted that a third party is the true culprit and not within a hearsay exception may be admitted only if the judge, in the judge's discretion, the evidence is relevant, will not tend to prejudice or confuse the jury, and there are other substantial connecting links to the crime. Citing some more cases. This court has the discretion to rule in advance of trial whether the defendant has made an adequate showing that potential culprits were connected to the crime. The defendant must provide advance warning to the court before offering third-party evidence or argument at trial. The defendant has yet to make a proffer of substantial probative value that any other individual is culpable for her crimes. The arguments previously set forth by the defendant in pretrial motions contain only vague inferences, rank speculation, and scant details of who, if anyone, had the motive, intent, and opportunity to kill the victim. A third-party culprit is simply a defense tactic to unjustly prejudice the Commonwealth and confuse the jury. Yes, well, we would not want the Commonwealth to not have a fair trial. For the foregoing reasons, the defendant should be precluded from alleging that any other individual is culpable for the victim's death, as there is no relevant or substantially probative evidence to justify the admission of such a speculative claim. Furthermore, despite this court's previous order denying the defendant's request to raise a third-party culprit defense, during the defendant's opening statement at the first trial, Attorney Iannetti was permitted to declare 3 separate times that Karen Reed was framed. Kind of like how Lally said, I hit him 4 different times, even though it was never in any reports or anywhere until trial that anybody said that ever. Should the court preclude the defendant from raising a third-party culprit defense, defense counsel should be ordered to conform their arguments to the orders of the court. XOXO. Michael Morrisey, Hank Breenan. And that was docket number 589. And that is to exclude third-party culprit. Okay. All right. Let's go to the chat for a second because we have a bunch of questions on this one. Grace Space is going to throw up. Don't throw up. Don't throw up. Because if she grants this motion, then it is 100%. 100% in the bag. 100%. The fix is in. The jig is up. Can PD's orphanage for wayward methodology? When do you think we will get the ruling for dismissal? I don't know. We could ask the Magic 8 Ball, but I don't know if the Magic 8 Ball knows either. I would imagine it's going to have to be soon. Only because, look, is the trial going to start or not? And I'm sure that she's got to write a really, 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 really long and well-reasoned decision to protect herself on appeal, even though there are so many grounds for a post-conviction, God forbid, appeal right now that do we need really one more? I'm going to just check the docket real quick to see because it's after 5, so everything that's been logged in for today would probably be logged in already. And I just want to make sure that it didn't hit the docket while we were talking about something else. But I'm sure somebody would have brought it to my attention if it did. So let's just hang for 1 second. It did not, as far as I can tell. If anybody has any information to the contrary, please let me know. I hope soon, but I cannot speculate. But thank you for your super chat. Amanda, thank you for your super chat. Great show. Enjoy your evening too in Detroit. Determined to get Melanie hooked on Shine Down. Lyrics and music are amazing. Love your coverage. Thank you very much. Thank you very much. Angela, thank you for your super sticker. K-Wags, I'm behind, but I feel like the death certificate and crash report are kind of important for a murder by vehicle trial. Me too. Me too. Well, I knew I was a member. Thank you, Piney. Aussie Steve, I watched a very emotional stream by Missy last night, seeing Breenan call Fanning, a highly respected cop. He lied directly about Sandra Birchmore's death. He's a part of the massive corruption. I agree. He's the one who quickly cleared Matthew Farwell. So thank you for that, Aussie Steve, and for tuning in from Australia. And Missy's amazing. She's dedicated a lot of her life and time to getting justice for Sandra Birchmore. Shouldn't the phone and emails between the judge and the prosecutors be discoverable? I think that is already in the works. With regard to Michael Morrisey's emails, I'm not looking at a motion right now. I can't stray too far from the topics at hand, because otherwise we've already been here for 4.5 hours, and I love you and I thank you for another super chat, but we just can't go there right now. All of AJ's Nichols, is Breenan allowed to say what kind of defense the dream team can use? How can he do that? They in Delphi, that's a great example. In Richard Allen, they were not allowed to use a third-party culprit defense. The judge ruled on it, and they are allowed. It is within the judge's discretion. Chloe Albert's revenge. How can I do my assignment if she didn't do hers? Clueless. Thank you for your super chat. I'm one such medical doctor parachuting in. Haas-Long text is enough to keep the third-party culprit. Yes. Jury can decide on the experts. Loving your stream as always. Right. The Haas-Long to dying cold thing points to a whole bunch of other people potentially trying to cover something up. I don't know that they need to point to exactly who that person is. Why does Morrisey not sign even through the computer? Because there's a special prosecutor assigned. So technically he's not the one trying this case, but great question. Thanks, Teresa. Angela, imagine if Rebecca Dietrich, that medical examiner from Penny McGee's case, had been the ME instead of this ME, the doctor who thinks anyone in the room with someone perishes is responsible for their death. Yeah, that would have been wild. Thank you for your super chat. Moving on. Oh, this is a good one. You're going to like this one, friends. You're going to like this one. This is 582, docket number 582. And this is Commonwealth's motion for offer of proof prior to the defendant calling or summonsing the Norfolk District Attorney, Michael Morrisey, and the victim advocate as witnesses, and request for an order that neither is subject to a sequestration order. So you're going to have to give us an order of proof if you want to call DA Morrisey to the stand, as if that hostage video that he made in August 2023 isn't enough. And they should be allowed to sit in the trial for the whole damn time. So how about that? That's what they want. In 3 pages or less. Now comes the Commonwealth, moves this court for an order that the defendant make a satisfactory order of proof prior to calling and or summonsing Norfolk District Attorney Michael Morrisey and victim witness advocate Steve Nelson as witnesses, and for a finding that the District Attorney and Mr. Nelson are not subject to any order of sequestration. So this is Morrisey. We'll just check the number 582. Trying to be organized, but there's just too much stuff here. So for those of you who don't know, Steve Nelson is the witness advocate who may or may not have had some communications with some of the witnesses with regard to whether or not there was a preservation order regarding their phones, which may or may not have caused some people to destroy their phones. We don't know. On March 6th of 2025, the defendant listed both the district attorney and the victim witness advocate as potential defense witnesses. Well, we haven't seen that witness list yet, have we? I don't think so. When a defendant resorts to the extraordinary means of calling a prosecutor as a witness, he must make a satisfactory offer of proof as to the need for testimony from the prosecutor. An offer of proof is sort of like a voir dire, where they could put the witness on the stand, ask them the questions that they want to ask them outside the presence of the jury, and then the judge can decide whether or not she's going to force them, in this case, to testify. DA Morrisey is the elected official of the Norfolk District, a position he was first elected to in 2010. Yes, and I think you guys can correct me if I'm wrong. I think he has run unopposed ever since, which is shock and horror in and of itself. As such, he is the elected advocate of the people and the chief law enforcement officer from the Norfolk District. Well, the people, the constituents might beg to differ, but he's the advocate of the people. He's the advocate for some of the people. Mr. Nelson is an employee of the Norfolk District Attorney's Office and is the assigned victim witness advocate in this case and has been assigned to the case since January of 2022. And then they go on to talk about some case law about what the victim advocate does. During trial, it's especially important that the advocate engage in an essential function of acting as a liaison between the victims and witnesses and the district attorney's office. Neither the district attorney nor the advocate were percipient witnesses to the charges before this court. Well, you know what? That's not really true, because Michael Morrisey got on television with his recorded hostage video statement and said, Michael Proctor was never at 34 Fairview. John O'Keefe was never in the house. So yeah, how does he know all that information if he's not a witness? Where did he get that information? Who told him that? Who told him to make that statement? Was anybody off camera holding a weapon? To the extent the defendant may want to impeach proposed Commonwealth witnesses as to statements, the defendant has not shown the absence of alternative sources of said purported information. Further, to the extent the defendant is seeking either the district attorney's or the advocate's opinions or observations regarding witnesses, mental impressions, research, or evaluation of the evidence for the Norfolk County case, such areas of inquiry reflect privileged work product. Well, guess what's not privileged? All of the emails and text messages that Morrisey made from his personal phone and his work phone, really. Because we know what he was doing with it. Therefore, the Norfolk County DA's office respectfully requests that this court order that prior to the calling or summonsing, the district attorney and advocate make a satisfactory offer of proof before they're allowed to call them. And that this court find that they are not subject to any order of sequestration. And that is docket number 582. Let's see. 583, the Commonwealth is making a motion wanting to use chalks. So I don't really think we need to go over that one right now. Because there's too many other bigger ones here. I mean, if we need to go over that another time, we will. That's 583. One minute, please. All right, let's see. 58. It's 585, 584. They want to celebrate demonstration for 584. They're looking, Commonwealth is looking to, they made this one last time too. Let Whiffen do an in-court demonstration. Hold on. Let me come back on the screen. They want Whiffen to be able to do an in-court demonstration and Jessica Hyde to do an in-court demonstration. I'm going to skip that one for now. Because I think there are more interesting ones here and I'm getting tired. 5-8, that was 5-8-4. Where's 5-8-5? Five 8-6 is the Commonwealth's motion in limine to admit the results of defendant's blood draw at Good Sam Hospital. So here they are. Here's that one. They want to admit those blood results, and we read defense motion wanting to exclude them, but according to their own papers, they say a defendant's medical record of the blood test is admissible because of the records of the kept by hospitals should be admissible. And we just read the entire defense theory on that no, there was no treatment involved, and so they should not be admissible at all anyway. And also junk science, and also not the proper testing, not the proper methodology. And so the Commonwealth anticipates that the medical providers who participated in the blood draw will testify to their knowledge, training, and expertise in how the test was administered to demonstrate their reliable basis. And the answer to that one is, I disagree. I strongly, strongly disagree. So goodbye to you, 586. Oops. 585. Oh, this is interesting. Oh, Commonwealth's motion in limine to admit the victim's out-of-court statements relating to his state of mind. All right, let's take a look at this. This has to do with the niece and nephew's testimony. They want to allow into evidence John O'Keefe's statement to his niece, nephew, family members, and friends regarding the defendant's intention to end his relationship with the defendant, and statements about the tumultuous nature of their relationship, which are relevant to the victim's state of mind. I mean, these kids were how old at the time? 11 and 13. I don't remember exactly. You guys can remind me. So they say that they want, I mean, it's hearsay. John O'Keefe is not here, unfortunately. And is there an exception to the hearsay rule? Let's see what they have to say here. That these statements that John O'Keefe made to these people are relevant to the victim's state of mind. We're kind of reaching now a little bit. I don't know if I remember from the first trial. If they were permitted to testify about such things. I don't recall if this motion was made the first time. And then it goes to the victim's state of mind. But the victim is no longer among the living. This is really like a lot of hearsay. The broad rule of hearsay evidence interdicts the admission of a statement made out of court, which is offered to prove the truth of the matter asserted. That is pretty much black letter law. The state of mind exception, it says, however, declarations out of court may be admissible to prove the state of mind or intent of a person when it is a material issue. The state of mind exception to the hearsay rule calls for admission of evidence of a murder victim's state of mind as proof of the defendant's motive to kill the victim, when and only when there is also evidence that the defendant was aware of that state of mind at the time of the crime and would be likely to respond to it. Oh, they're going to say that John said that he wanted to break up with Karen, and then therefore Karen knew it, and then therefore she killed him. I mean, A murdered victim's attitude of contempt or hostility toward the defendant when it is known to the defendant would constitute some evidence which, augmented by other evidence, might warrant a fact finder's determination that the defendant responded by killing the victim. Oh my God, we are reaching into the trees at this point. Yes, and Maloney's law points out, no doubt those kids have been poisoned against Karen by the O'Keefes. By all accounts, she was very generous to those children, bought them things that John would get mad about her spending too much money on them, buying the niece Dunkin' Donuts iced coffee before school, and that made her a bad person too. Hank has some really dangerous karma for trying to get the children back into the trial. I agree. Like they weren't already traumatized enough from having to testify against Karen at the first trial. Maybe they're already traumatized because, remember, somebody came out and said, I know what it was in that Phelps podcast. One of the people who was interviewed, who's friends with the McCabes, said during that podcast, several of the children involved have had to go to inpatient and outpatient mental health treatment. She outed them, remember? As if it wasn't traumatic enough for these children that perhaps they're thinking, oh, did we do something wrong? Did we not testify properly? And therefore we have to go through this all again. Is it our fault? Our fault? Yep, losing both of their parents plus John. Isn't it enough trauma for the children? They go on to say there need not be direct evidence that the defendant learned of the victim's state of mind, so long as the jury could have reasonably inferred that she did. The Commonwealth intends to introduce statements the victim made to his family members and friends close in time to the murder about his relationship with the defendant and his decision to terminate the relationship. Well, you know what? Go ask Ms. McKinney, Esquire, what she thinks about who's a liar in this trial. Practically every witness she's listened to thus far on TikTok, and she's awesome and funny and hilarious. Call me, girl. Call me. Come on the show. The Commonwealth also intends to introduce the victim's statements through text messages authored by the victim and contained within the victim's cell phone that express his decision, communicated directly to the defendant to terminate their relationship. Okay, well, if you have his own text messages, why do you need witnesses to testify about double, triple hearsay things that maybe he did or did not say? The Commonwealth contends that the victim's state of mind is relevant to the defendant's motive to kill him. The defendant and victims, because, you know, he wanted to break up with her. So she was going to kill him. I just want to point out, she was a very successful woman who made a lot of money. I'm going to guess that she probably made more money than John. And she wouldn't just leave, break up with him. She needed to kill him, make it make sense. I can't. Hang on a sec. Whereas the defendant has repeatedly accused others of committing murder. Oh, here we go. Here's the tattletale. The tattletale has entered the chat. The kid in elementary school who tattled on everybody all the time. That's Spanky. This is the little rascals. Lally is alfalfa because of his little shark hairdo that he used to wear during the last trial. Little shark fin, bubble bath hairdo. That makes Laura McLaughlin Darla. This is the little rascals. He's the tattletale, Spanky. Where the defendant has repeatedly accused others of committing murder, the jury should be permitted to consider all evidence that demonstrates the relationship and hostility between the defendant and the victim at the time of the murder. The probative value of the victim's statements is relative to the defendant's motive to kill him. Haas longed to die in cold. 2:27 a.m. Google search happened. The probative value of these statements outweigh any possible prejudicial effect, as the statements are being offered only to prove state of mind and not the truth of what was stated. Yeah, no, this is garbage. It's garbage. It's garbage, but you know what? She's going to allow it. She's going to allow it. And you know what? Somebody protect the children. Can anybody please, anybody show of hands? Can somebody try and at least protect the children? Any potential prejudice could be remedied through a jury instruction on the limited use of state of mind evidence. You know what? Juries don't understand jury instructions. They don't understand reasonable doubt. How are they going to understand your instructions? The whole reason there was a mistrial in this case is because your jury instructions suck. They suck. To use the words of Marietta Sullivan, your jury instructions suck. The jury didn't know that they could reach a partial verdict and they could acquit on counts 1 and 3 because you told them don't fill out any of the papers until you have reached a consensus on all of the counts. And here we are in double jeopardy land. And now you want to just, I can't. Right. And when the jury instructions are an hour long, who's listening to them? For all these reasons, the Commonwealth respects that we should be allowed to do another thing that nobody would ever allow in other jurisdictions. But, you know, because it's you, Judge Bev, XOXO, please, mommy, please. Love, Michael Morrisey, Hank Brennan, Adam Lally. Oh, this time they decided to use a nicer cursive font for the signatures. Look. They've morphed it into something like an engraved Tiffany invitation. Look at the new font, everyone. We're going to make it fancier. It's fancier, so that means we're more serious now. Will you take us more seriously now, please? That's how you know they were listening. Somebody said that's funny. Okay, that's 585. So goodbye, 585. It was nice. You'll probably get a little scribble scrabble on you soon. Just saying, sure, I'll allow it. Sure. I work harder than Judge Bev. Yeah, I know. Right? Right? Do we have 586? Let's see. Where's all my papers? Let me just look. I want to look at the list of things so that I can pick like the most important, interesting things for you so that we can kind of wrap this up soon. All right. Here's your choices. Oh, wait. We have some defense motions that look interesting. Oh, Well, there is a defense motion to prohibit the Norfolk County District Attorney and Massachusetts State Police from having juror contact. That has been impounded, so we're not going to be able to see it, but that's a great motion, and I'm happy about it because I'm sure they have a lot of detail about how and why the MSP had contact with the jury and why they shouldn't going forward. That looks like it's impounded because there's probably a lot of really juicy information in there. The Commonwealth has made a motion to allow counsel to state their grounds for objections to promote judicial economy and efficiency and to adequately preserve interests. Well, that's interesting. The Commonwealth wants to have to state the grounds for their objections. I mean, that's nuts. That's 595. Then we have defense motion to exclude false and irrelevant statements of Michael Proctor. It's 591 and 592. See what that's about. What is this? What is this? 587. What are you? 587. Oh, a Commonwealth's motion to preclude reference to any alleged bad character and any prior misconduct of the victim or any witness. Oh, that could be interesting. Commonwealth's motion in Limine to prohibit reference to any pending internal affairs investigations and sustain findings unrelated to this case or unfounded allegations of misconduct. Well, we can pretty much guess what this is. But let's see what this is, because this looks a little bit interesting. Let's see this. This is 587, docket number 587. This is the Commonwealth motion in limine to preclude reference to any alleged bad character or any prior misconduct of the victim, John O'Keefe, or any witnesses. Well, this has piqued my interest, and it's only 3 pages. So let's see what are the examples. We would like you to order the defense team to refrain from making any references before the jury of any alleged bad character or alleged misconduct of the victim or any witnesses without prior court permission. You need to ask mommy's permission. Mother, may I? Remember that game, Mother, may I? Specifically, the defense has made allegations about civilian witnesses and law enforcement witnesses, and the public has been saturated with unfounded claims of bad acts by the Commonwealth witnesses. At the previous trial, the defense lodged a slew of claims of alleged bad acts of witnesses. Indeed, the defense has engaged in a comprehensive campaign to inundate the public. Oh, I need my pen. A comprehensive campaign to inundate the public with its claims, and repeatedly has declared or implied that the Commonwealth, the prosecutors, the court, trial court employees, and witnesses are corrupt, declaring that virtually every civilian witness, police officer, and first responder was complicit in a cover-up of evidence, and implying that nearly every witness is a liar. Well, you know what? You're being a little hyperbolic. A little hyperbolic. But you know, if it walks like a duck and it talks like a duck, it's a duck. Such allegations have no foundation nor bearing on any issue in this case and would constitute impermissible bad character evidence, like the 227 search. Whether during the opening statement, during cross-examination of any Commonwealth witnesses, during the direct examination of the defendant's witnesses, or during closing argument, defense counsel should be restrained from making such references unless obtaining prior court approval. Oh, you mean like the bang bang video? Like the pull-up bang bang? The Colin Albert videos? What else do you think they're referring to here? I don't know. Is he going to give us any more detail? Let's see. A judge may properly exclude evidence that is introduced merely to show the bad character of a witness. Further evidence of prior misconduct may not be used to impeach a witness's credibility except by production of records of criminal convictions pursuant to the limitations and requirements. The busted knuckles. Yeah, the busted knuckles. The alleged busted knuckles of Colin. All of the impeachment evidence. Yes, because they've got to turn it over. Remember, they got to turn over all their impeachment evidence. So, you know, here's the bang bang video. Enjoy. Here's the pull up bitch video. Enjoy. Yeah, Proctor did read his text on the stand. Alleged. All right, here's why you shouldn't allow it. Here's some cases saying you shouldn't allow it. You shouldn't allow it. You shouldn't allow it. But are you going to give us any examples? Evidence irrelevant to the issue at trial or to a witness's reputation for truth and veracity is inadmissible to impeach a witness. If they've got a problem with telling the truth, isn't that exactly how you impeach them? What? Any bad character evidence of infidelity? Oh, here we go. They're going to get into the infidelity. Infidelity. For those of you who don't know about the alleged extracurricular activities in the last month of Paul O'Keefe, go read turtleboynews.com. He's got a story on it with screenshots and maybe receipts and maybe a bathroom selfie. Any bad character evidence of infidelity. Oh, and then there is maybe some, I don't know, could be some other witnesses who also were unfaithful, but I don't know. I don't know that for a fact, so I can't say. Propensity to consume alcohol or the defendant's suggestion without any factual support that every witness is a liar or participated in an unfounded scheme to frame, quote, frame the defendant has no bearing on any of the issues raised in this case. Well, actually, Karen Reed was framed. This is inverted. Microdot sells them on their website or YouTube page or something. And that may be true. The defense should not be permitted to introduce bad character nor specific bad acts of the victim or any witness. The proposed evidence only serves to disparage the victims and the witnesses' character and to distract the jury. Yeah, Mickey says, Karen was framed, so there's that. Chloe Albert's revenge is like, I just read that and saw and listened to it, and I rebuke all of you for telling me about that. I'm sorry. I know it's hard. It's hard to unsee. Yeah, like exactly like Chris Albert killed a man. Well, they didn't bring that up in the last trial. XOXO, please don't let any of this bad stuff in. I don't think it means the text messages necessarily, Kristen. I think it means, maybe some people have been to rehab since the last trial. There has been some rumblings of that. I don't know. Maybe they've got proof of it. But if that's true, and if certain people were alcoholics, it could go to their memory being faulty, right? Perhaps. There's a thing called wet brain, and it really does exist. We could ask Dr. Renee Stonebridge about that. Any other ideas, thoughts about what they're trying to keep out? That was a good one. 587. Bad acts of witnesses. Well, we've got a lot of questions here, so let's get to some questions. If there's anything specifically that you would like to see, specifically, we have some time here. 591 and 593, someone saying. Motion in limine to exclude false and irrelevant statements of Michael Proctor. You want that? I mean, I've got them all, but let's go to some questions first. All these kids, it was like they were all allowed to drink. I don't know. I don't know what goes on, what the culture is like there. It's insane. Pev's over stamp. Oh, you changed your name. I like it. From Canada, could substantial probative value be DNA testing of the carpet from 34 Fairview? I don't think so. That's my opinion. But I think it would be too expensive. There's no chain of custody, and you can't use it as a shield and a sword, right? So I don't think so. But good question. Amy, Hank's showing only the small piece missing from the taillight. Is he going to make 47 pieces of taillight now irrelevant? Change his theory? I don't know. Thanks, Amy. Dirty Hanky is here. Says, thank you, Melanie. The battle of the truth versus lies. Yeah, it's David versus Goliath. Thank you for your 20. Canton PD's orphanage for wayward methodology. Oh, that is well done. There's so much reasonable doubt here. It just made Guinness World Records. Yeah, I agree. Thank you. This trial won't be a battle. It will be war. It is war. It is war. The army is here. They're coming, Nina. I know you know. Chloe Albert's revenge. Michael Morrisey framing Karen Reed. Carrie Morrisey tanked the Baldwin trial. Sabrina Morrisey keeping Wendy Williams locked up to steal her money. Can we all vote Morrisey's off the island, please? Oh, wow. Well done. Well done. Thank you, Chloe Albert's revenge. Josh says, how is the Hosselong to die search, Higgins destroying phone, not evidence of possible third party? Yeah. The defense shouldn't have to prove who was the third party. I agree. I'm going to have to read some of those cases maybe to opine further. But again, they could change their theory too. We don't know who did it, but we do know that John O'Keefe was not hit by a car. Right? And all of that other evidence leads to reasonable doubt. And the jury shouldn't be back there trying to figure out who did it. This is not a mystery. This is not a murder mystery dinner party. I agree with you. Thank you, Josh. Down to the menace. Hanky in English slang is called a snark. Thank you very much. Reed's bite is bigger than Chloe's. Oh, well done. READ. That's the defense team. Hey, Bev, just a little reminder that Spanky's making more money than you. as you're buried under this boatload of motions. Have a nice day. CPU Mod 1 is she's Tom's sister. I'd love a Melanie Little sweatshirt or any merch that says the papers, maybe missed with the Boston accent. Love you, Melanie. I can't even remember what that's from, but it's like an old comedy sketch, and it's like, you got to find the papers. Where are the papers? You got to sign the papers. And I'm racking my brain to try and figure out where in my past history that is from, and I can't think of it. If anybody thinks of it, let me know. Get the papers. Do you have the papers? Sue's just read all the text messages from that day. John begging her to come to Canton and stay for the weekend. Yes, Glare and I did that one night on his show. We did a little dramatic reading of the text messages, and he did. He was begging her to come. They tried to say in the beginning that she crashed guys' night. Masters of Criminology is here and says, listening to all of this tells me that no speedy trial promised by Hanky. I think he's going to try and beat the record set by Lally. Maybe. Thanks for super chat. Kyle, Depthy heard disallowed a tape because a person passed away. Yes. Thank you. Chloe Albert's revenge. We all know the best way to keep a guy is to off him. Then he's yours forever. Brennan's been watching too much Lifetime. Thanks, Chloe Albert's revenge. Can't be D's orphanage for wayward methodology. Thanks for the 10. What I don't get is how the whole of the Norfolk Legal Department can look at anything Brennan has done and think, this is the best candidate for the Reed persecution. Well, and they had to pay for it. When they have at least 50 attorneys on staff inside the office that could have handled this. Thank you. Padeline Loon is here from Canada and says, look up Wisconsin versus Jensen. Victim's letter was admitted and guilty verdict was overturned, and Robert Jambois, re-prosecuted it. Well, when I have time for some homework assignments, I will take that under advisement in Wisconsin v. Jensen. Thank you. Whoops, for your super chat. Anybody in the chat who wants to look that up? There it is, Wisconsin. I think it's Wisconsin, right? V. Jensen. Thank you very much. Lisa Louise is on a replay. You're very welcome. Alessi's Google search not. I was willing to give Brennan the benefit of the doubt, but he really is a mob lawyer. Well, but that's a fact, right? He's playing dirty. Gray space, aka Commonwealth's motion to please not impeach our witnesses. Yeah. They got to turn over their impeachment evidence anyway. Hank's trying to hide behind Andy Bev's robes. I have to temper my language here. Thank you, Suze, for playing. Thank you, and your super chat. And Scooter, thank you for your super chat. And Bella Brat. Okay, every time I think I've gotten used to it, Mel, you say Colin Albert, and I lose it. Colin. Bang, 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 bang. Colin's coming for you. Oh, there's so many. Listen, it's not our fault. We did not rename him Colin. It was Robert Cosgrove, the special district attorney in the case against Aiden Harney. He called him Colin, not us. We're just repeating it. Jam Cracker, thank you so much for today. What brand of iced coffee do you buy or do you brew your own? I brew my own. And I always have like pictures of it in the fridge. But also, I am a Dunkin' girl. I'm a Dunkin' girl. Starbucks for me, if I go to Starbucks, it's for iced matcha. If I go for iced coffee, you know who also has a great iced coffee? 7-Eleven. 7-Eleven has this machine that grinds the beans and makes your iced coffee right in front of you. I know, it's crazy. I know. But this 7-Eleven is very high end. They're cleaning it constantly. It's the cleanest place I've ever been. And it is very good. But when I have it at home, I do brew it and then I put it in the fridge. And I also have a coffee maker that brews iced coffee, which is very nice to have. So thank you for asking. Thank you for diverting me from the Karen Reed case for a second, because we all need it. Kelly says, successful, intelligent women kills boyfriend who she thinks cheated at a time and place with witnesses because he wanted to break up. Yep, nothing to see here. I know. And all the curtain twitchers. Kathy, our friend from Gossip, Rumor, and Innuendo, give her a sub because she's great and she's hilarious. She's not touching this case and I can't blame her, but she calls these people curtain twitchers that are always peeking out the curtains because they're like the nosy neighbors who always want to see what's going on. And so they know everything. They're the curtain twitchers. Well, according to Jennifer McCabe and Matthew McCabe's own statements and testimony, they were looking out the window the entire night. They were curtain twitching. So if they were curtain twitching, how come they didn't see this accident happen or hear it or see the body on the lawn? Make it make sense. You can't make it make sense. Lindsay Judge, please exclude all things bad for our case. Exactly. That's exactly what this is. And I popped out and came back, and you're still going your machine. Thank you. Well, I was trying to get through everything today. I think what we're going to do is probably come back tomorrow, and because there's probably going to be more things and stuff. And this way it's going to give me a chance, because everything was coming in so quickly that a lot of it was just cold reads as they were coming in. We were reading them in order, and I kind of want to go back, see what we didn't do, see what's percipient, what we need to do. Thank you for watching. Meatball Marcy, Sketty Stain. So, Sir Spanks-a-Lot want to have a one-sided trial. I'm confused. How is this fair to Karen? It's not. It's not. The deck has been stacked against her since the day she was arrested, since the day they seized her car, since the day they found his body, since the day they decided to pin it on the girl. Karen has the right to confront witnesses and impeach. She does, yes. But again, land of the lost, Hunger Games. Sues, they want to keep Chris Albert's wiretapping hidden. He has been audio recording for a long time. That's what I hear. They want to keep that out, right? That could be also one of the things they want to keep out, prior bad acts of witnesses. Yeah, good thinking. Hank Morrisey Canoni, would a FOIA request of other cases in Norfolk County include who was in charge of each jury and jury security? That is MSP always present, or is it unusual? I think it is unusual. I have been told that according to the court rules, it is always supposed to be court personnel in charge of the jury. Well, the judge says that he was not in charge of the jury, never had any contact with the jury, saw the jury, or not that he never even set foot inside the courthouse, she said. And how dare you impugn his character, Fanning? I don't know if a FOIA request would reveal that, but maybe somebody in the chat can help you. And please, if you do know the answer, would you tag Hank Morrisey Canoni? Thank you. Nina, do you know about Fanning and Crawford's video editing company? Yes, I did. Yes. And also, yes, they had to close because the case was dismissed due to their altered videos. I did a whole stream on that. Pulled up the documents in that case regarding the death of Keith Boudreau and the civil motions related to that case, in which it is alleged that Colleen Crawford and Fanning might have altered some video in the murder trial of Paul Fahey. He was, in fact, granted a new trial for prosecutorial misconduct because of, among other things, the district attorney calling him a bully many times in the closing, and some other reasons. I haven't been able to dive deeply enough into it yet, but I know that there is a girl on TikTok, and she's also, I think, on YouTube, and she's hilarious. What's her name? Nerdy. I want to shout her out, so hang on, because I'm going to look it up, because I want you guys to go follow her. And I hope that she fell into this rabbit hole. I hope, because she saw it on my show, because that would be so cool. Let me go to the history. Is her name it's something like Nerdy Pink Mom, but hang on a second, because I don't want to misname her. But she did a deeper dive into it, and she had a lot more information, and it was really good. I'm just looking at my history to see if I can find it, because I think she posts her video, because I don't use TikTok. So I think, or I have a TikTok, but I don't really use it that much. Or maybe somebody sent it to me and it's on Twitter. Does anybody know? Anyway, she's great. Nerdy Pink Mom, I think, is her name. She did a deeper dive, but yeah, they also had a company. Nerdy Pink Panda. Thank you, Nerdy Pink Panda. Thanks, Olivia. Right? She's awesome and she's hilarious. Thank you. Thanks, you guys. Nerdy Pink Panda. Got it. But yeah, they also had a business that was dissolved like 3 days after John O'Keefe's death. So they may have been, maybe they've been altering video together for a long time. Kelly, block all defense, hide anything that goes against our case, hide any witnesses, law enforcement issues, but our case is strong. Hank's no supervillain, not even Dr. Eel. You got it. You got it, girl. You're catching on. Lil, the defense motion to keep out any inference that Officer John O'Keefe was hit by a car since it was proven that he was not. Put that in your pencil, Hanky. Thank you, Lola. Not that Dina. Oh my goodness, a $50 super chat. Thank you so much. Says, hello, gorgeous. I'd love a t-shirt with Melanie Little's droppings. Oh, that's funny. That is funny. Thank you. Thank you, Nina, for it's not that Dina. Not that Dina for the 50. Super generous, and I appreciate you. Love you with all of my heart. The Papers is from Goodfellas. Is it from Goodfellas? Sue Becca. All right. Okay. I'm going to have to go back and watch that. The Papers. Maybe that is exactly where it's from, because I watched that a million times. And it's so funny because not funny. Ironic. Isn't it ironic, don't you think? That in Goodfellas, remember? Karen, when he's out there and he's in the car and the helicopters and the withdrawal and the drugs and Karen. Christine, thank you for all you do. Thanking me. Thank you. Thank you, Christine. Sue says Chris may have wiretapped the juror. She was allegedly at. I'm not going to put that out there into the universe, Glamour Sue, because that could be defamatory. But thank you for your super chat. Appreciate you so much. KT Mualam. It's insane they want to try Karen Reed without letting her have a defense. I've never seen anything like it. Check out Delphi. If you haven't, check out Delphi. Andrea Burkhart, my girl, and also Defense Diaries did both amazing work on Delphi, and same thing. A lot of commonalities between this case and the Delphi case, the murder trial of Richard Allen. Richard Allen was convicted, and a lot of similarities. Thank you, Mama She, for your $80 Cash App, who says you work so hard. I'm so grateful. I'm so grateful for you. So grateful for you. Stephanie, thanks for the Venmo, who thinks, what do you think the odds are for the trial to start on April 1? There's a lot of work to do. There's a lot of work to do, and not all of this work is going to get done. If the judge wants to do, Taco Tuesday, Half Day Friday, get to the Cape, stay in the Cape Mondays, it's not going to happen. But here we are. It's March 11th. It could happen. It could happen. I don't know what's going on with the federal appeal. I don't know that there's any sort of, we don't know how long that's going to take. Although the judge, I think his name is Saylor, did say that he thinks that he's going to try and decide it quickly. So I don't know what the odds are. I wouldn't take that bet, I don't think, Steph, but thanks for the Venmo. Allie, thank you. By not allowing the undetermined to be included in, it will only taint the jurors. Yeah. I mean, not knowing the manner of death, they didn't allow it in last time. Oh, thanks, Piney Woods, for your Venmo. Love you too. Love you too. Let's see what else we have here. Got some info on Turk. Hold on. Let's see. Oh my goodness. Okay. From inside the courtroom, I'm not going to name my person who was inside the courtroom, says we were going to, and like I said, we were going to cover the Turk hearing live today, which is in the same courthouse. Harry Turk, a prominent robotic surgeon accused of killing his wife, Katie McLean, says, the person who's in the courtroom says, Kevin Reddington continues to push for a change of venue, citing you, Melanie Little's ongoing blog coverage of the case, as a concern. He also mentioned that something had been planned for today, but he did not know what it entailed. The judge, however, seemed to ignore that point. The next hearing is scheduled for March 24th at 11 a.m., which appears to be the day they will begin selecting the jury. Reddington is requesting that it take place in the larger courtroom. Yeah, well, I think that it was assigned to the larger courtroom. And this is interesting. You may recall Kevin Reddington's name because he represented Jennifer McCabe in these proceedings in the Karen Reed case. And we did have a live stream planned for Turk, but I canceled it because it wasn't going to be, it wasn't going to be televised. So I'm sorry to ruin your argument for you, Mr. Reddington. But yeah, for those of you who don't know, I've made it when Kevin Reddington is talking about me in court. And, just as a side note, because I was going to show this today, but since you're all here, let's take a little look. This is my claim to fame this was a couple of weeks ago, and I was actually on an airplane when this happened, and you guys sent it to me. So I was watching it. I was watching it on the airplane, and I had to quickly screenshot it and send it to my whole entire family to say, look at me, you guys, I'm famous, check it out. So this was the hearing. With homicide. This is the hearing from like 2 weeks ago. This is Kevin Reddington. He represented Jennifer McCabe. And I'm going to turn off the closed captions, but he's going to talk about me in a second. Let's see if I can cue it up here. Because it's not the first time he talks about me in court. All right, is it back here? Hold on. He was arguing for a change of venue because there's so much publicity about the case. Right. They put my name like on the chyron, so let me just see if I can find it. Do, 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 do. That's Dr. Turk right there sitting at the table, see, on the left. Dr. Harry Turk. That's Kevin Reddington standing up. So we have a lot to catch up on this trial, but hopefully I think it's going to be over before Karen Reed's trial begins, so we can do both. I think maybe it's towards the end because this is the prosecutor. Ugh, the court TV with those commercials. Hang on. I wish I had a timestamp for you, but hang on. We're getting there. We need a little break anyway for a second. Oh, here's the change of venue. Pretrial publicity. Listen.
I will point out, Your Honor, that of late and recently, the new thing now is the YouTube. And Your Honor, I'm sure is aware with the Karen Reed case that there are a lot of YouTube people. They get into the sensational aspects of the trial and they pick it apart, and they have a lot of people that sign on and they listen to it and debate it and talk about it, which is fine. There's one individual who I think has some credibility, and she seems to be very intelligent and is somewhat fair in her observations. Melanie Little is her name, an attorney from New York. And then there's a lot of other people that are more salacious and into talking about...
I'm not salacious. And here it is. I'm on the Chiron defense. There is one person who has some credibility in talking about the case, Melanie Little. What? Did you hear what he said about me? How pissed off do you think Jennifer McCabe is right now? How pissed off do you think Jennifer McCabe is right now? Let's hear what he said about me again. Hold on.
Which is fine. There's one individual who I think has some credibility, and she seems to be very intelligent and is somewhat fair in her observations. Melanie Little.
Fair in her observations and intelligent.
Little is her name, an attorney from New York. And then there's a lot of other people that are more salacious and into talking about...
How do you like that? I'm not salacious. I'm intelligent, and my observations are fair. Can't use it as a shield and a sword. Can't say I'm salacious and unfair in Karen Reed, but not in Dr. Turk's case. Yeah, so there's that. I made it. I made it. True story. Reddington was just fired by McCabe when? Today? Because of this? Oh, no, you mean you're joking. Yeah, so there's that. YouTube people. There's YouTube people. Can I watch this clip outside of D&E Pizza? That's hilarious. Says Melanie Little's left swipe in StreamYard. Hilarious. Colin Alisi is here. My boss was having a meeting today with a guy that sounded just like Prosecutor Breenan. That's funny. Kelly, if Fanny only worked outside the courthouse, is he picked up on anyone outside court recordings? You think someone would have him on tape if that's true? Great point. Don't know. I'm sure the armchair detectives are working hard on it. Thank you on top for both of you super stickers. I love you with all of my heart. So there's that. And apparently, according to my in-court watcher today, he was pushing for a change of venue and talked about me again. This was from about 2 weeks ago. So there's that. So I've made it. I am a figure to be reckoned with in Norfolk County Superior Court. You heard it here first. And I can sometimes do a Boston accent occasionally when the mood strikes. I want to thank each and every one of you for coming to hang out with me today. I know this was long. I know that we're probably going to come back tomorrow and do some more, but I think for right now, what we need to do is take a breath. And perhaps, take a beat. There will be so many more things to cover tomorrow. I think we should probably do a cupcake invasion. So some people don't allow it. They don't allow it. I don't know why. Who's live now? Let me look at my subscriptions and see if I can find out who's live. Do you want to go to Defense Diaries today? You want to go see Allie and Bob? You want to do a little cupcake invasion over there? I mean, they're already into it. They've already been into it for like 2 hours, so I can send you over there. What do you think? Yes? Okay. Tell Bob and Allie that I said hello. Let me just see if they allow it so I can redirect. And, you know, that's what we do here. We're givers. We're givers. Just clear your calendar for tomorrow, friends, because I have a feeling we're going to see a lot more stuff. All right, they're already into it for about 2 hours. So head on over to Defense Diaries. Say hello to Bob and Allie. They are an excellent. You're going to Defense Diaries to see Bob and Allie Mata. Let me just make sure that I didn't miss anybody. No, I think we're good. I think I thanked everyone properly. If I didn't, I'm sorry. I'll thank you tomorrow for your coffees and matchas. Thank you to the moderators who keep it classy and have been with me endlessly. And this seems like it's endlessly, but we're here for it. And we ain't got no quit. And we're never giving up. Free Karen Reed. It's going to happen. It's going to be our 4th acquittal that we're going to see together. I have a feeling. To all my channel members, I love you with all of my heart. If I don't see you soon, I'm going to die. Viewers, replay viewers, do all the things that YouTube likes. Please hit the like button, hit the subscribe, hit the bell, do all the things and stuff. I love you. This was a very interesting afternoon, and we're not done yet. We're not done. We're coming back tomorrow. I'm going to transport you to Defense Diaries in 3, 2, 1. Safe travels, my friends.